Yes. Inclusion, come back next week, please. We'll just dispose of some of the matters and then.
Lordship,
All inclusion, same answer.
Lordship, this is not for inclusion, Lordship. Lordship, I beg for leave to file this appeal without certified copy.
Why?
Lordship, the certified copy has been applied for, but Lordship, the
Leave
urgent.
is granted. Leave is granted.
Lordship, grateful.
Item number 1, Lordship.
What is the correction? Yes.
The correction is that para 2, 5 and 21,
Yes.
where respondent number 2 to 5 is written.
Oh.
It shall be respondent number 1 to 4.
2, 5 and 21.
Para 2, para 5 and para 21.
Oh, it should be respondent numbers 1 to 4.
1 to 4. And second, para 29.
Para 29, yes.
Para 29, whereby the judgment, not the citation number is wrong.
Oh, achha. What should it be?
It should be AIR 2000 MP 83.
And I'm just pulling. Counsel, you are for the respondents.
Respondent
Then
plaintiff.
counsel for the respondents, comma, in paragraphs 2, 5 and 21, comma, instead of respondent numbers 1 to 4, comma, the transcription reads respondent numbers 2 to 5. Full stop, next para. As such, comma, the correct numbers would be respondent numbers 1 to 4 instead of respondent numbers 2 to 5 in the said paragraphs. Full stop, in paragraph number 29 of the judgment, comma, the citation recorded would be AIR 2000 MP 83 instead of AIR 2013 SC 3204. Full stop, let the above two corrections be deemed to stand incorporated in the judgment dated May 20, 2025. Full stop. Let this order be deemed to be a part of the said judgment for all practical purposes and for issuance of certified copies. When you apply for certified copy, apply for this order also.
Great.
Thank you. এটা আপনার নামেই করে দিচ্ছি জাজমেন্টটা, আমি আই এগ্রি করে দেবো। এটা অঙ্ক তুমি জজ সাহেবের নামে করে দেবে। অবশ্যই এটা তো অর্ডার ফর্মে হবে। অর্ডার ফর্ম, হ্যাঁ ঠিক আছে, আই এগ্রি তো।
Item number 2 is my.
আচ্ছা কি বলছে? জমা দিয়েছি।
Item number 2, I am for the respondent.
Paper books have been filed, Mr. Mukherjee, in this matter?
No.
Not yet filed. There was a direction by us to give a report as to whether the LCR, some of the pages of the lower court records are torn and lower portion of the pages are missing. Naturally, old matter.
But I, in my humble submission, that I have gone through those pages.
Would not have any
impact on hearing of the appeal.
Any impact, very well. And the will has also come.
Original will has come, so
Yes.
therefore the appeal is otherwise should be ready.
But the
for
original will does not bear office seal of the presiding officer of the trial court. Was it exhibited? Was it exhibited?
It was exhibited because it was contentious. And
Mr. Ghosh, was it exhibited? Because it was marked as exhibit number 1.
Yes, exhibited.
it was exhibited.
So very well, whatever it is in that form, let us deem that the records are complete, and whatever procedure is to be
Well,
done.
kindly direct me to prepare the paper book within
You
a
are for the appellant?
Yes.
Well, we'll direct you to prepare the paper books.
My lord, the paper book direction is already there.
There, acha.
And that direction was passed, I think, in
Acha, acha.
2019.
Yes, not some time may be granted.
We'll
because-
extend that time.
Yes.
We'll extend that time. From the office report dated May 23, 2025, we find that the trial court records have arrived before this court, although some of the papers are in torn condition. So we also find from the said report that the will, within bracket exhibit number 1, has arrived before this court as well, although it does not bear the office seal of the learned presiding officer of the trial court. Since we cannot improve upon the documents which have already been marked as exhibits, let the office treat the records to be complete and proceed with finalization of the appeal for hearing. Next para, the appellant, the time for filing paper books by the appellants is extended for a period of 3 weeks or
No,
three-
4 weeks, better 4 weeks.
4 weeks from date. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
My lord, I have an application pending, CAN 4.
What is that for?
In that application, Lordship, I'll just give a brief background of the matter.
What is the prayer in that
That
application?
the prayer is that the
Inventory.
house property which is of the testatrix should be allowed to be opened. It's a more than 100-year-old
Directed
house.
application to be listed as an application? Can 4 of?
CAN 4 of 2023. And because I am unable to maintain that property.
We'll consider that when it comes up before us. It is appearance to be mentioned today.
Let that come up as an application then.
Can 4 of 2023 be listed tomorrow under the appropriate heading? It application heading a can দিয়ে দেবেন কাল।
I'm obliged.
Thank
Obliged. my lord.
You have served Mr. Ghosh a copy.
Yes, yes, I have served directly to his.
We'll consider that when it comes up. Does not deny. Does not deny. He does not deny. Yes. Next.
Your lordship granted me liberty.
Yes, Mr. Chakraborty.
Well, the problem is, well, CAN number 4 of 2023 itself contains certain mistakes. My earlier advocate on record, my lord. In fact, what the name to be added was respondent number 8. He said
Can it be cured by filing a supplementary affidavit?
that is the reason my lord, I was thinking, subject to your lordship.
Whatever you say, no, you proceed in your own.
No, my lord, I will be filing my supplementary affidavit so that
How much time do you?
no, my lord, only thing I will consider number 8.
Yes.
Clause title in the number 8 would not be there. So possibly my lord will be desiring that it should be withdrawn with liberty to file afresh.
That will be better.
Possibly.
File it properly. Yes, Mr. Chakraborty, you are right. Learned counsel appearing for the appellant submits that there are certain defects in CAN 4 of 2023 and seeks to withdraw the said application with liberty to file afresh. We agree with the such submission of learned counsel and dismiss CAN 4 of 2023 as withdrawn with liberty to the appellant to file a fresh application on the self-same application and incorporating further prayers as deemed necessary by the appellant.
Extremely grateful.
Let the matter go out of the list for the present with liberty to the appellant to mention the application for inclusion in the list as and when the same is filed.
Including the order 41.
Whenever it is filed, Mr. Chakraborty, you just have it mentioned. We'll take up the mention it as an order for turn matter.
Next
Have you given a copy to the other side?
Well, I have given. I have supplied.
You are for the other side.
Yes.
Very good.
No. He is my advocate on record.
No, then you keep your receipt. No, the new application you also have to serve.
New application, along with my lord, I will come with the affidavit of service. My lord,
Actually, we will direct that also.
my lord.
As in, we further direct the appellant to serve a copy of the application, as and when filed, on the learned advocate for the respondents. They are represented in.
My lord,
Advocates
they are.
on the learned advocate for the respondents and file an affidavit of service on the date when the matter is next taken up.
Extremely grateful.
Thank you very much. If you serve a copy, Mr. Chakraborty, have it mentioned as an order for turn matter when you next mention,
I'm extremely,
along with that application.
I'm extremely grateful.
Thank
My lord, I am for the petitioner
Yes.
led by Mr. Proceedings.
You are for the appellant.
appellant.
Yes.
He is engaged in code number 8.
He may be engaged, but what is the matter about? Unless you say that, we'll dismiss it. You'll have to apprise us at least what is the matter about.
No,
Then we'll dismiss it for default.
no, my lord. Only not today, my lord.
No question of not today. You have to tell us what is the appeal about. Juniors are not granted adjournments in this court unless they open the matter. You have to start the matter and tell us what is it against. At least what is the impugned order. Go through our brief. Come prepared. After 10 minutes, we'll take up the matter. You just sit here, ma'am, and go through the file. And tell us when you take up the matter. You don't go outside the courtroom. We are not permitting you. You sit here, take the file, get prepared. We'll take up after a few minutes. Say around 11:15, we'll take up the matter. Yes, call on the next. দিন তো আগের দিন না থাকলে ডিসমিস সার্টিফিকেট আজ কিছু নেই তো কোনো বাইরে কিছু যুদ্ধ ফুদ্ধ দেখলে না যুদ্ধের নিচে কিছু হলে দেবো না from the records that the appellant sought an adjournment on September 24, 2024 before a coordinate bench, pushed up even on June 9, 2025, when the matter was last taken up for hearing, none appeared to move the matter. Full stop. Today is the when the matter is called on for hearing today, none appears for either of the parties as well. Full stop. Accordingly, SA number 121 of 2022 is dismissed for default without an orders to cost. যখন রেজিস্ট্রেশনটা করবে অ্যালাউ করে বলবো তুমি অর্ডার করতে নিয়ে করে দাও বলবো রেজিস্ট্রেশন অ্যালাউ করবে অর্ডার করতে অ্যাপ্লিকেশন কনফিউজ ওই অ্যাপ্লিকেশনের সঙ্গে অর্ডার করতে সেম অর্ডার না সরি সেম অর্ডার হবে না আগের ডেটগুলো আলাদা This is a second occasion when none appears for the parties at the time of call. Accordingly, SA 147 of 2022 is dismissed for default without any orders to cost. Thank you. Same order. আগেরটা যাবো সেকেন্ড লোকেশন ডিসমিস
যাক কিছু যাক
অন্য অর্ডার করতে অ্যাডমিট ইনক্লুড করতে পারছি না লিস্টে
লিস্টটা তো বলকি হয়ে গেছে
যারা চায় তাদেরটা নেবো এগুলো সব ডিপার্টমেন্টের গুলো না ওই সেকেন্ড লোকেশন সেম সেকেন্ড লোকেশন নন অ্যাপিয়ার্স ডিসমিস করে আচ্ছা এটা হবে along with can 1 of 2022 FMA number such and such along with can 1 of 2022 are dismissed for default without any orders to cost. ফলটা খারাপ কাজ দিয়ে শুরু হচ্ছে সেম হাত ফাত ধুয়ে নিতে হবে গঙ্গা জলে Dismissal certificate না হলে এটা আসবে
Smaller 10 manner, I beg to appear for the
Thank
appellant.
you for coming. Yes, at least we have some good work to do.
Your Lordship, on the earlier occasion, it was taken up. My Lord, one of
Yes,
the.
you have trained your learned junior well. This is the matter where he moved this application yesterday.
Yes.
You have trained your junior well, Mr. Banerjee. Congratulations. on that. Yes. You
My
move
Lord,
on.
suit for partition, injunction order passed on contest. Against that, I have come up. Your Lordship, for your brevity, Your Lordships, I have given a bunch of documents, handed over a bunch of documents to Your Lordships.
Yes.
Just now, my Lord. Your Lordship would kindly take the family tree for once. My Lord, it will be
Right.
easier for.
Yes.
My Lord will find that is their plain case.
This is a
that,
photocopy from your handwriting. You have good
yesterday
handwriting.
night, I somehow it ought to have been done in
No,
computer.
it's good. It's a good handwriting.
My Lord,
We are envious.
admittedly, my Lord, the plain case is,
You are which side?
my Lord, I claim title from Bhadu Sheikh. My Lord, their case is that there are Jogendor had two sons, Soleman Bhadu and one Bhanu Bewa, that's sister. Now they claim title from this Bhanu Bewa. We deny the existence of Bhanu Bewa altogether. And in support of that, my Lord, we rely on two documents of title. One, executed by the brother Soleman in favor of Bhadu Sheikh, he gives his 8 ana share.
8 Anna means he admits that there are only two.
Two.
Right.
My lord, that my lord would kindly takes the order impugned. Court does not come.
What is the second proof? You said you have
and the
proof of-
second, my lord, their case is that Bhanu Bewa, there was a deed of exchange between Bhanu Bewa and Sheikh Suleiman.
Yes.
That deed of, there is no deed of exchange, my lord. They simply say that it's an amicable exchange. My lord, without mentioning, I'll go reading
Oral,
over
I mean,
the.
they don't produce any document.
No, don't produce any document. My lord, court on this basis, my lord, passes an injunction order on contest.
But this is tribal in this.
But this is travel. But
Evidence of
difficulty is this, my lord.
If in a
where
partition suit, if you deal with the property, the general principle is that it's kept in statu quo.
my lord, status quo, my lord, I know, my lord, Israel versus Shamsher, my lord, is
No, other.
there are others also, but my lord would kindly takes into consideration a person, my lord, whose source of title I am denying and disputing, and court comes to a perverse finding that no, I have not come up with any document to show or to reveal that there is no existence of this sister. My lord, how can I prove the negative? I'm asking this question to myself. The best thing I can have is that title deed executed by Sheikh Suleiman.
Apart from that,
That's the my
argument regarding this Bhanu's existence, any document was produced by them to show that Bhanu existed?
no,
Anything?
no, nothing.
Please place the
My lord, I'll take the
Yes.
kindly takes the order impugned.
impugn order. Yes, second paragraph.
Kindly takes
Hard learned advocate. after
peruse the pleadings, application, written objection, and documents filed by the party. It prima facie appears that the plaintiff had acquired right title interest over the suit property by virtue of purchase from the legal heirs of Fatima. Fatima is the Bhanu's Bhanu Bewa's legal heir. Nothing has come forward before this court to prima facie show that only Sheikh Suleiman and Bhadu Sheikh had got the suit property by way of inheritance from the deceased Jogindranath Barik. Well, this is the only case I have before your lordship. This is absolutely a perverse finding.
Let us see what on
But
perusal of the
thereafter, my
document.
learned advocate for the defendants verbally submits that on defendant number 1 has transferred her share to Aloni Bewa. The said Aloni Bewa is necessary party to this suit, and as the plaintiff has not added as her a party to the suit, the
Aloni Bey, we're not going so much because you have to prove it. On perusal, thereafter, what the court
on
realized.
perusal of the documents filed by the plaintiff, it prima facie appears that the defendant number 1 had sold her share to one Halima Khatun, who is already a party to the suit. Nothing has come before this court to prima facie show that defendant number 1 has sold any property to any person in the name of Aloni Bewa. Oh, no, this is
Different.
different.
other things.
But my question that was put forth before the learned court, that was not considered, and the court has come to a perverse finding. But this ought to have gone into in detail by.
Can you please show us from your written objection, Mr. Banerjee,
Yes.
that you have taken this?
My lord,
point of
kindly
page
takes the bunch of documents,
Got the
page
documents.
9 and 10.
Yes. This is the written statement.
Yes,
itself?
this is the written statement.
Yes. Where have you stated that
Yes.
he does not exist, he or
Yes,
she?
yes, and done.
Is it
My lord,
he? Bhanu
and
is a
this
she.
paragraph,
Bhanu is she or he? Bhanu?
Bhanu is he.
Bewa, you say?
No, I just,
Bhanu is daughter.
Bhadu is he, Bhanu is she.
The
Like
one who does not exist is a she.
She, yes,
Very good.
sister.
So where have you stated she does not exist?
Yes, paragraph 10 onwards, my lord, I have stated that. My lord would kindly takes.
We want to see the specific abatement.
Yes, yes. আরজিতে যোগেন্দ্রনাথ
Yes. ভানু বেওয়া নামীয় কন্যা ছিল বলিয়া
রজকের তান্তে তো ভানু
We'll
বেওয়া
admit-
নামীয়
we'll
কন্যা
admit-
বলিয়া
We'll admit the appeal, but no stay at this stage.
Yes, I have not
We'll
taken
direct the service of memo as well as the usual.
No, my lord, one thing, my lord, I have not filed any stay application also. my lord.
Rightly so, rightly so. We'll direct you to prepare paperbooks.
Yes,
and
yes.
Come back and what is can one was recording did that to have
Yes, that's
that the previous
Yes.
last option. Very good. This is the most correct approach, in fact, Mr. Banerjee. We appreciate that. You're growing very well.
no,
Good to see that. মানে যে গোড়া থেকে দেখছি ভালো সিভিল লুকিলে এটাই হওয়া উচিত ফালতু কোনো অ্যাপ্লিকেশন করে appeal has been preferred against an order of temporary injunction passed in a partition suit at the behest of the plaintiff stroke respondent number 1 Pushap Learned Counsel for the defendant numbers 1 to 6 stroke apparent submits that the said defendants defendants took a specific point in their written statement as well as written objection to the injunction application in the code below that Bhanu Bewa, one of the one of the alleged heirs of Jogindra Rajok, as per the plaintiff case, does not exist. Full stop. However, the learned trial judge, while passing the order of temporary injunction, glossed over glossed over the issue and apparently cast the burden on the defendant stroke appellants to prove such negative fact of non-existence of Bhanu Bewa, thereby committing a legal error. Full stop. In view of the above submissions, we find that a sufficient case for hearing the appeal on merits has been made out, and accordingly we admit the appeal to be heard on the above question as well as the other grounds taken in the memorandum of appeal. Full stop. The appellant shall put in due requisites for service of notice of the appeal on the respondents within a week from date. Are the trial court records necessary, or can you prepare informal paper books?
My lord, the documents that were placed before
May
the
be
court.
necessary. Very good. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. আবার আমাদের ডিফল্ট অর্ডারে ফিরে যেতে হবে। This is the second occasion when none appears. A template করে নাও। জাস্টিস এম কে মিত্র ঘরের বাইরে লাগানো থাকতো ইউজুয়াল অর্ডার।
আপনি বলেছিলেন এর সঙ্গে 50টা শট এগিয়ে গেল।
একজন ঢুকেছিল ঘরে, সে ভেবেছি ইউজুয়াল অর্ডার করতে অ্যাডমিট করে দিই, সে বলে ইউজুয়াল অর্ডার প্যাটার্ন গুলো বেশিরভাগ এইভাবেই যাবে, ফাইলগুলো রেডি রাখো। হ্যাঁ ঠিক আছে, দুদিন করে হলে রেজিস্ট্রেশনের সঙ্গে অ্যাডভার্টাইজ শুনে অ্যাডমিশন হিয়ারিং করে দেবো। একটা কথা তাড়াতাড়ি আসছে না, সেম অর্ডার। না না,
কালকে যত ডেফার হয়েছে সব তো
কেউ লিস্ট দেখে না তো সেম দেখি, না না পেজ না সেম দেখতে পাচ্ছি, সেম লিস্ট খালি করে কিছু ঢুকিয়ে সেগুলো হিয়ারিং করে দেবো, তার মধ্যে এরা রেজিস্ট্রেশন করবে, যখন রেজিস্ট্রেশন করবে এগুলো ঢুকিয়ে ওগুলো
যারা ইন্টারেস্টেড আছে ওদেরকে
ফাইলটা দেখান ওখান থেকে। হ্যাঁ সেম yes.
This is my appeal, my lord. However, my lord, the main suit, my lord, has been withdrawn from the commercial court.
We are anticipating this in some of these matters. That's why we are dismissing for
And my
default.
lord,
Whoever is interested will come and
I
we'll
have some
hear.
predicament, my lord. This is a commercial appeal, my lord. This arises from the order of the commercial court of Rajarhat. So, my lord, perhaps,
So we don't have determination also.
my lord, that is why
Has it become infructuous in the meantime?
it has become infructuous. Maybe we have withdrawn the main suit, my lord.
We'll record that and dispose it off. We'll say, we'll give our reasons for taking up despite not
My
being.
lord,
We'll record your
my lord,
submission.
kindly takes it up after 10 minutes, my lord. I have the papers, my lord.
Definitely. We'll pass it over for 10 minutes.
My lord.
Whenever you have the papers, come back and
I-
mention, we'll take up in the
As
next
your
meeting.
lordship wishes.
We'll just say that we don't have determination, but due to this reason, instead of again pushing you back to the commercial court for this innocuous thing, let us pass
Grateful,
some
my
illegal orders also. Yes. Next. এটা ওই উনি এলে আবার তারপর একটু সাইড করে রেখে দিন, পাস হবে। দেখি সেম ওই নান অ্যাপিয়ার্স সেকেন্ড কোড, সেকেন্ড টাইম, সেকেন্ড অকেশন when none appears. আচ্ছা একটু সরি, এগুলো সংখ্যা একটু দেখে নিও, এগুলো যদি কোনো কানেক্টেড Yes, this is item
My lord,
17.
for the appellant, my lord.
Yes, Mr. Samanth, move the
My
matter.
lord,
18, sorry.
it has been informed from my counterpart in the learned court below that the appellant has died, my lord, without any heirs.
Without a, oh,
My lord,
so
he don't-
abated.
My lord, he
We'll record that. We'll record
probably the police has taken out his body, that as with the informant. No,
that. When?
because there is no person living with him.
Oh,
He was a very
very
old
sad.
man.
So we'll record that and hold that the appeal has abated. When did he die? Do you know that?
My lord, no information.
We'll say it has become infectious then.
When the matter has came before, Lord, I informed my
Very
learned
unfortunate.
counterpart. He informed me.
Learned counsel appearing for the appellant submits on instruction that on instruction from his counterpart who had appeared for the appellant in the trial court, comma, that the appellant has met his demise in the meantime during pendency of the in the meantime without leaving any heir and legal representative. Full stop. Accordingly, FA 182 of 2023 and CAN 1 of 2023 are dismissed as infructuous without any order as to cost. Interim order, if any, stands. There is no interim order.
This is first time, my lord.
Interim orderটা দরকার। Thank you. এই জন্যই তাড়াতাড়ি শুনতে যাই, কোনটা কখন হয়ে যাবে দেখে যেতে পারবে না, লিটিগেশন শেষ হলে।
None appears.
The matter was adjourned on May 13, 2025 on the prayer of the appellant, which even on May 21, 2025, none appeared for the appellant as well as the respondents. Full stop. Today, comma, at the time of call, comma, neither the appellant nor the respondents are represented by counsel. Full stop. Accordingly, FMAT 586 of 2023, along with CAN 1 of 2024 and CAN 2 of 2025 are dismissed for default without an order as to cost. About the default order. Second occasion, none appears, dismissed for default. Yes, Mr. Madhu, we are expecting you to come at least. What is the matter about?
Alright, suit is for partition. Alright, defendants are the appellant before your lordship, judgment of affirmance.
Preliminary degree, Mr. Mahato?
Well.
Yeah.
Alright, our case in the defense case was that there was a oral partition. Therefore, the property which have been purchased by the plaintiff's my lord cannot be treated as joint property, and those property cannot be come into the hodgepodge of this suit. That was my defense.
Share was sold to them.
Yes. My lord, the learned court has taken into consider the exhibit F, which is a my lord registered deed of partition. And my lord says that since there is subsequent partition, therefore the earlier oral partition, the story taken by the defense, taken by the defendants, cannot be accepted. But by the very exhibit F, the suit plot is not there, which supports my case that prior to that partition deed, the property, the suit property was given to my vendor.
But Mr. Mahato, if your contention of oral partition is to be accepted, then regarding the other portion also, there could not be a partition deed, because that portion would also be divided. Or was it, I mean, you said that out of the total property, a particular portion by amicable partition was given to you.
Plot number.
Plot number was given to you.
That plot number has not
Not been
subsequent deed.
Acha, in the subsequent deeds, there has been a partition regarding the other plots.
Persons and other plots.
Just
not the suit plot. My lord, suit plot is 3265. Area is my lord 72 decimal.
Can you please repeat once? Plot is number?
Plot number 3265.
Yes.
And area is my lord 72 decimals. Original owner was my lord Gajendra Narayan Acharya. My lord, subsequently Bhavo Shankar got the property.
Yes.
He transferred by executing a registered deed to 4 persons: Ananto, Amullo, Boikuntho, and Kanai.
Hmm.
My lord, so far the defendants numbers, my lord, 1, 2, and 3. My lord, they have got the property from Ananto and Amullo by exhibited document registered deed in respect of plot number 3265.
Mr. Mahato, but difficulty is elsewhere because the trial court, sorry, the trial court says, among other things, that because even if supposing we don't proceed on the basis of that partition deed, you have to independently prove that oral arrangement. But court says that you have neither adduced Amulya Ratan Das Adhikari, the vital witness of the amicable arrangement, nor produced record of rights. So you could not
My lord,
prove the
therefore,
amicable arrangement.
during trial, my lord, during appeal, I filed the additional evidence, order 41, rule 27, producing, my lord, the record of rights, which shows that by virtue of the oral partition, the record of rights, my lord, was prepared in the name of Ananta and Amulya. Therefore, the property was partitioned orally.
How was it dealt with by the appeal court?
Yes, my lord. So for the order 41, rule 27 application, my lord, the appeal court has rejected that.
By the impugned judgment itself.
My lord, if your lordships kindly come to page 4 of the first appellate court judgment. Third paragraph, the appellants preferred 2 petitions under order 41, rule 27. One application by producing, my lord, to record of rights, other, my lord, the khajna receipt. And
Khajana receipt showing that you had been paying khajna for this plot.
my lord, my vendor paid the khajna.
Vendor.
Yes. And the other is, my lord, order 6, rule 17 for correction of certain rate. By the first petition, the appellant have prayed for adducing additional evidence in the form of certified copy of the settlement record of ROR prepared as per West Bengal Acquisition Act in the year 1954-57. The second petition speaks of a prayer of amending Khotian number. This is not application for amendment. It is instead of 491, it should be 499. And the same is cited formal prayer for amending sentences. The respondents have filed objections against the petition. The another petition under order 41, rule 27 have been filed by the appellants on such and such incorporate rain receipts of the appellants in respect of the suit property. No written action solution. Then, my lord, findings. The pivot point of the argument of this appeal is about the oral partition. So for the order 41, rule 27, if your lordships kindly come to next page, second paragraph. A careful look at the written statement indeed shows that the oral partition is said to be find mentioned in RSROR. However, I find no such affirmation in the petition filed by order 41, rule 27. The settlement record has also not been filed before this court to ascertain this fact. In such case, the same could have been looked into for necessary reference. My lord, I could not understand these observations. By filing order 41, rule 27, I have produced those documents, but the court has says I have not filed that. My lord, these are the application under order 41, rule 97, order 41, rule 27. Where, my lord, the record of rights was produced.
Mr. Mahato, exhibit F was that document that
Yes, a subsequent
let us
registered deed
please
of
come to page 6 of the appeal court that has also been dealt with. Court says itself says that you referred to this portion of the deed, but you are the court is afraid that it could not find a single averment in respect of the suit property in exhibit F.
Therefore, it is supports my case. Their suit property has not been included in exhibit F. Therefore, it has been given to my vendors prior to that. Prior to execution of this document, the property was given to my vendor. Therefore, there is no mentioning in the exhibit.
Instead of this going against you, should have gone against in your favor.
It is my submission. It is my understanding also. And I have checked up, my lord, the exhibit F. It does not include, my lord, the plot number or anything about that plot number. It shows, my lord, that the property was given to my vendor prior to that. And prior to the section 14 come into force.
Given by way of oral partition.
Well, It is, my lord, prior to
Once
nineteen
partition
fifty-one.
has been completed, then every property in the hot pot should be divided among the parties.
My lord, that is not the case of the plaintiffs also.
ও যেটা বলছে কবিতা যেটা বলছে সেটা হচ্ছে টোটাল প্রপার্টি ছিল ওরাল অ্যারেঞ্জমেন্ট ফ্যামিলি অ্যারেঞ্জমেন্ট করবেন সেটা ওপেন হিসেবে যখন ফ্যামিলি অ্যারেঞ্জমেন্ট করেন এই পোর্শনটা তখন ওকে দিয়ে দেবে ওটা একটা সোর্স ব্লক রাইট আচ্ছা এবার পরে একটা এক্সিবিট এফ হলো তাতে দেখা যাচ্ছে এই বাকি পোর্শনটা নিয়ে
আর তাহলে এই ওরাল পার্টিশন হয়নি অ্যারেঞ্জমেন্ট থ্রু অ্যারেঞ্জমেন্ট ওরাল দেখেন
ওরাল পার্টিশন বলতে মিউচুয়াল অ্যারেঞ্জমেন্ট
পার্টিশন তো গোটা প্রপার্টি দিতে হবে আদারওয়াইজ পার্টিশন
সেটাইও বলছি এটা যেটা বলছি সেটা হচ্ছে যে যদি এটা না পার্টিশন আগে হতো বা মিউচুয়াল না হতো তাহলে তো এই যে এই যে পার্টিশনটা হলো যেটা কোর্ট উল্লেখ করছে তাতে তো এটাকেও ঢোকাতো এটাকে বাদ দিয়ে বাকিটা final decree proceedings, but shall not draw up any final decree with the prior leave of the court, of this court. Full stop. The appellant shall, will direct you to put in the requisites and the appellant shall put in requisites and postal costs for service of notice of appeal on the respondents within a week from date. The trial court records shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a week from date, full stop. The trial court, comma, however, comma, shall retain skeletal records for the purpose of continuing with the final degree proceedings. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the application as well as the appeal for inclusion as and when the same is ready for hearing. Thank you. Yeah. স্ট্রেস দিতে চেয়েছিলাম। Accepted. Apologies. But your junior has to start. That was the precondition. Otherwise, we won't take up the matter. She has to start it. You can pick up. Come back tomorrow. We'll take it up tomorrow. We are very, adamant on these things. She has to start. We won't take up the matter unless she starts. She has to tell us what the matter about. Then we'll pick up from there. You can argue. You have to prepare your juniors, Mr. Mukherjee. Come back tomorrow.
Also, affidavit of service.
Take back. ফেরত। Just not today করে রাখুন, কিছু order record করতে হবে। But remind us, Mr. Mukherjee, if you forget tomorrow. Yes. এটা দেখুন। আরে এটা দেখুন। দাঁড়িয়ে আছে সামনে। Yes, you have got the papers. What did you say? The suit has become infructuous.
Milord, suit has become infructuous. My injunction application, Milord, was dismissed. From that injunction application, I preferred this appeal. Ultimately, Milord, the suit was withdrawn by the plaintiff. Milord, this is the final order of the learned commercial court.
You are the defendant.
I'm the plaintiff, Milord.
Oh, you challenged refusal of injunction.
Refusal of injunction. And this is the instruction which I received from clients, Milord, for withdrawal of suit before the.
We are ready with everything. Learned counsel for the appellant rightly points out that this bench does not have determination to take up commercial matters. Full stop. However, comma, instead of relegating the appellant for the innocuous order which we propose to pass, as will be indicated herein below, comma, we choose to take up the matter for such limited purpose. Full stop. Learned counsel hands over a communication, the photocopy of a communication as well as a server copy of a printout of a server copy of an order indicating that the suit from which the present the suit, comma, in connection with which the order impugned in the present appeal was passed, comma, has itself been withdrawn by the plaintiff in the meantime in the court, in the trial court. Full stop. Next para, as such, comma, the appeal and the connected application have become infructuous. Full stop. Hence, comma, FMA 129 of 2023 along with Can 1 of 2023 are dismissed as infructuous without any orders to cost. Interim order, if any, stands vacated.
Extremely grateful.
The papers, the documents filed in court today be kept on record.
Grateful.
আবার কমার্শিয়াল কোর্টে যাবে বেচারা শুধু সব ফালতু টেকনিক্যালিটি তে শেষ
22, Milord, I'm appealing for the appellant.
Yes, Mr. Chair. Yes.
There are two defects. Milord, one is deficit court fee that we have put in. Milord, this is the document that we have put in. And Milord, another defect, Milord, is with regard to the Milord name of the respondent number or defendant number 5.
Yes.
Milord, that is Jibon Chakraborty. Milord, the trial court in decree recorded as Prashanto Chakraborty. Milord, this is beyond my scope.
So it requires a correction of the decree.
The department.
This is the trial court's decree.
Yes, in the trial court's decree, Milord, wrong name has come
Appeal
up.
court's decree is all right.
Appeal court decree has not even recorded that. So, Milord,
so let us proceed. After order আগে নিয়ে learned counsel for the appellant hands over photocopies of documents to indicate that the deficit court fees have since been put in. Full stop. The office shall furnish a revised report in that regard. Full stop. Insofar as the other defect is concerned, comma, it is submitted that the name of the defendant number 5 in the suit was incorrectly recorded in the trial court's decree. Full stop, next para, the records be sent down for such correction. Full stop, subject to the above comma, we take up the appeal for hearing under order 41 rule 11 of the Code of Civil Procedure. Yes.
Now, my lord, it's a my lord, suit for eviction of a licensee, my lord, judgment of affirmance. My lord, I have only 2 points to raise here.
Yes.
My lord, my point is, my lord, the license was granted in the year 2004, August 1st of August 2004. My lord, as per the plaint case.
Yes.
Now, my lord, the person who files the suit, my lord, he becomes owner of the property by virtue of a registered deed registered in the year 2005. So that is, my lord, on my lord, 29th of November 2005. So, my lord, as on 2004, my lord, he was not the owner. So, therefore, my lord, for licensee to be granted, my lord, the licensor has to have an interest or an ownership over the property, which was not there. So, my lord, my induction as on 2004.
Plaint says that he inducted you as a licensee?
Yes.
Or that you are a licensee?
No, he inducted me as a licensee.
But there are judgments, Mr. Chatterjee, you have to prove your status, whatever.
No, my lord, I say, my lord, I was
You have to
there.
have a better title.
No, he gets a title in 2005 virtue of purchasing it. My lord, if I am a tenant, my lord, this doesn't fall, my lord, and I am governed by the rent laws.
Your defense was that you were a tenant.
My lord, I was a tenant under the erstwhile owners.
What proof did you produce?
My lord, yes, my lord, to hear, my lord, if my lord takes up the plaint case once, my lord, the judgment, my lord, if my lord takes up
the trial court judgment?
Yes.
Yes. Did you produce any rent receipt or anything?
No, my lord, I do not produce rent receipt, my lord, but my lord, in the evidence also, my lord, the plaintiff says, my lord, he was never in possession. I was in possession since 2004, and he purchases in 2005.
Maybe, so what?
So, my lord, I was there in the property.
Permissive occupier, if you are not a tenant.
Now, my lord, if
either you have to be an owner or a tenant or a permissive occupier.
Absolutely. My lord, today, my lord, the issue is whether I'm a licensee or a tenant.
The issue is whether he has a better title in an eviction suit.
My lord, subject to correction, my lord, in a suit for eviction of a licensee, Honorable Supreme Court says, my lord, two things have to be looked into. If I'm in an exclusive possession of the property, then it cannot be a licensee. First. Second, my lord.
Exclusive possession is one of the characteristics of tenancy.
Yes.
Not the sole characteristic.
Now, my lord.
That has to be evidenced from an agreement, from the clauses of an agreement that
yes,
you have.
Absolutely, my lord. The agreement.
There was an agreement between.
There was a license potro, which he has produced before the court.
Achha.
Now, my lord, in the license potro, there is written, I am given in possession of the property, my lord, for a certain period, and after that, I will vacate. Save and except there was no control shown. My lord, when a commission was held, my lord, their commission found, my lord, I have made several construction in the property. My lord, I have made staircases, I have made rooms, my lord, always there. My lord, this has been, my lord, recorded in the impugned judgment, and my lord, at that point of time, he was not the owner. My lord, under the rent laws, landlord may be the owner, may not be the owner. So, my lord, if he becomes a landlord, my lord, then I am governed by under the rent laws. My lord, he accepts, my lord, he has received rent of 2000 from the license potro itself. So, my lord, I need not specifically adduce, my lord, further rent receipt to show that whether I have paid rent or not. Now, my lord, this is one of the issue. Another, my lord, point which I urge, my lord, today is, my lord, in the plaint, my lord, he himself says, my lord, by virtue of the sale deed which he purchases, my lord, the schedule is misdescribed. There are mistakes in the schedule. Now, my lord, to overcome this, my lord, both the courts have relied upon a judgment passed by this honorable court.
Schedule in the
sale deed. And, my lord, the plaint case is, my lord, the total property is of 9 decimal, and out of certain portion he has brought it. So, my lord, both the courts have relied upon a judgment passed by this honorable court, wherein, my lord, a question with regard to schedule of the plaint was considered. That misdescription in schedule will not be a fetter. Taking that judgment, my lord, the court says this misdescription in the deed will also not be a fetter.
What does the deed say?
My lord, the deed describes the property. My lord, there is a misdescription of the property.
What is the misdescription?
My lord, yes.
It's described as what?
My lord, kindly takes up the plaint.
The same property is mentioned.
But the entire was not purchased. This is the plaint case.
Was a demarcated portion sold?
No. My lord,
then also he becomes a co-owner. He has a right to evict you.
No, my lord, if that be so, my
As a
lord,
co-owner also he has a right to evict.
yes, yes, every
He's a better
co-owner,
title than you.
every co-owner has a right to evict me.
Yes.
But today, my lord, he says, my lord, he has inducted me. Now, my lord, if his induction goes wrong, if his induction, my lord, is of a tenant, my lord, his license patra is giving
But you say that he did not induct you. You are inducted.
No, I'm
previously.
inducted by his erstwhile
He
predecessor.
says that must be saying
And-
that because he produced the license.
And my lord, interestingly, the two deeds which he has produced, the vendor's deed and his deeds, both the deeds were registered on the same day,
Maybe it was
on
a sham.
29 November 2005. And he admits in his evidence he was never in possession.
No, how could he be?
So, my lord, admittedly, I'm in possession much prior.
Otherwise, would not be required to
So,
file
my
an
lord, if I'm
eviction.
in possession of much prior and a commissioner's report come in before the court saying that I have made constructions over the property and license patra is only to the extent that I am being given in possession. And my lord, he accepts rent of rupees 2000.
Who accepted the previous one?
No, he says, as his case is he has inducted, he says I have accepted the rent of 2000.
Rent or license?
Oh, my lord, it's not written as license fee, it's amount of rupees 2000.
Where is the license patra?
Yes, my lord, I have brought it. My lord.
Was the license patra? If it was mentioned as a license patra in Bengali,
Yes, in
then
Bengali,
both
vernacular.
parties were very conscious that it was to be intended to be a license. Because there is no direct translation in Bengali, that's why license patra is used.
My lord, to that, my lord,
Otherwise, it would be a Bharatiya.
no, no, my lord, to
There is
that,
no exact translation of license as opposed to tenant. Probably that was the reason in Bengali it was written as license patra. That itself shows it was a license procedure.
my lord, give me a moment, sir, my lord.
License patra lost.
No, no, it's there, my lord, I've seen it.
Must be with Mr. Shoykot Chatterjee.
No, no.
He has given exclusive permission to you regarding the brief.
No. My lord, this is the license patra.
Yes, shows there.
My lord, kindly marks, my lord, excuse me for the
No.
marking. My lord, nomenclature on the top is license patra.
That is not the only.
And my lord, inner thing, my lord, which I have read.
Bangladesh own license. Yes.
And
Where
my
is
lord,
your marking? Let us see your marking. আমার মালিক হতো। সেটা তো
my lord, he says I'm being given in possession, no control is shown.
বসবাসের জন্য অনুমতি চাইলেন।
Yes, my lord, there is no control. My lord, tenant also seeks an permission, my lord, or my lord request to give possession.
বসবাসের অনুমতি দিল। You are permissive. You are permissive occupant.
Now, my lord, I have.
You have two grounds. One is that that exclusive possession was given to you.
Yes.
Second is that the schedule means description of his sale deed. And courts relied on two judgments which speak about plain
Now, my
misdescription,
lord, if
which has no direct bearing on this issue.
no issue. Now, my lord, with regard to the second point, my lord, of schedule, my lord, a co-owner, co-sharer can file a suit for eviction, but my lord, a landlord, my lord, a co-owner, my lord, who has not inducted me unless a partition
If
happens.
he's a landlord.
My lord, he is not landlord inceptionally, he's subsequent
No.
purchaser.
Yes.
So, my lord, a subsequent purchaser in an undemarcated property will get only a share, not a demarcated portion. His demarcation also, he himself in the plate says, is not properly described. So, my lord, today, he cannot by virtue of that sale deed come and say, I have been given that portion of the property where I am there. So, today, if he is not there by virtue of that description, my lord, he becomes co-owner in anywhere of the property. So, can he become, my lord, a landlord, my lord, to the extent where there are other co-sharers saying that by virtue of the sale deed, he becomes a landlord. If he doesn't become a landlord, my lord, he becomes a landlord under the rent laws. If he says he has accepted rent.
Provided he's a landlord and not a licensor.
Yes,
He stepped
absolutely.
into the shoes of the original owner. Whatever the original owner was, he has become. If the original owner was a licensor, this is the permissive occupation. We'll take into account.
My lord,
this.
one
Can
judgment.
we keep a copy, retain a copy of this? Because we have
Yes,
to keep one copy of this.
Yes, yes, yes.
Whichever way we either admit or.
My lord, I shall make a photocopy. I have one copy of this.
Oh, acha. Do that during the course of the day.
My lord, one judgment I would rely
Yes,
upon.
yes.
কি তোমার জুনিয়র কোথায়? জাজমেন্ট গুলো? আমি my lord, excuse.
When you send your clerk for photocopying this, you also send your clerk for
Yes, yes.
photocopying
Lord,
that.
I'm just handing over the relevant.
The copies were handed over to my junior.
Whereas
Could not come to court, that's lying.
clerk could not come to.
No, my junior.
My lord, first I rely upon paragraph 17 of this
What is- give the
decision
citation?
reported in 2011 3 SCC page 7110.
Yes.
My lord,
710.
710.
2000?
11 volume
Yeah.
3 SCC
Right.
page 710,
Yes.
which says, my lord, it defines, my lord, who is a licensor. My lord, he says licensor has to be the owner. My lord, other than owner, there cannot be a licensor. So, my lord, as on 2004, he was not the owner. So, my lord, he doesn't become a licensor as on the date of my induction as per his plaint case. As per his plaint case. So, my lord, if he is not the owner, my lord, he becomes only a landlord, nothing more. And my lord, one of the illustrations in this judgment in illustration A, what my lord was, my lord, looking into, my lord, of possession. My lord, Honorable Supreme Court says, if my lord looks into the illustration, my lord says giving of possession for residence, simpliciter, my lord, is not a licensee, is not a license. Rather, it gives an exclusive possession. My lord, this judgment says, my lord, a licensor has to have a control over the property. But there are as many as 7 illustrations, my lord. My lord, and all the illustrations I have checked up with regard to the possession giving of residence. My lord, illustration A covers my case. And in this was a case where, my lord, an agent was seeking to be, my lord, in exclusive possession by selling a product. And, my lord, paragraph 35, I am not correct, 38, my lord, court has said this is only that this matter, my lord, issue, as he was an agency, principal agent relation was described and held to be a license. Sorry. My lord, with regard to paragraph 17, kindly says, my lord, there
Paragraph 17 of this judgment.
of this judge. My lord, he has to be the owner. My lord, without the ownership, there cannot be a license under the.
Did he say that he inducted you?
Yes, he said that is his plain case.
Where is that reflected in the transfer judgment?
Yes. Kindly.
Purchased the property by dint of a registered deed of sale in 2005. Since then, plaintiff have been in possession.
Yes.
And how did you prove that you were in possession from previously? From the license, his license potter itself.
Yes. My lord, I was there in 2004 since. So, my lord, he says he has inducted me. So, my lord, in 2004, he was not the owner.
No, what does he say in the plaint that he inducted you specifically?
My lord,
you don't find
I
that?
hand over the plaint, my lord. Itself.
You do better.
Yes.
Give a copy of the plaint and just refer to the relevant
that paragraph.
Yes.
My lord, paragraph 5, my lord will find.
Yes.
My lord, after purchase, he says he permitted me to occupy. And that's his evidence also. My lord, kindly see his
But the
letter.
license potter is prior to that date.
Yes. That's why I say on that date, he was not the owner. My lord, he might be the, my lord, landlord. I'm not saying he's nobody. But he cannot be the licensor. My lord, today, my lord, whatever has happened as an eviction of a licensee. My lord, if I am a tenant, my lord, I am governed by the rent laws. I'm entitled to the protection under rent laws.
No, but he himself themselves produced a license potter of previous
Yes, absolutely. So, my lord, as a landlord, he allowed me, as per his plain case in 2004 August, my lord, he allows me to enter into possession. And my lord creates a license potro. Now, my lord, nomenclature.
say 3rd or 4th Shravan 1411, that date corresponds with after his purchase, or yes, no, he says.
Milord, 2000, Milord,
Very short
license patra was executed on 1st of August 2004 and he purchased on, Milord, 29th of November 2005. That's the exhibited document, Milord, deed, which is marked as exhibit also, Milord.
Father of the plaintiff. Question. He said they were in possession from previously.
Yes, that is their case. So, Milord, as a landlord, he can allow.
Yes.
But, Milord, to be a licensor, Milord, under Easement Act, Milord, under definition of license, he has to be the owner.
Why should he be the owner?
Milord, kindly takes up the Easement Act,
Not
Milord.
applicable in West Bengal, but even then.
The principles would do
principle,
apply.
yes.
Milord, if my lord
Why
takes,
should he be the owner?
Milord, first, Milord, the Easement Act.
If I am a tenant, suppose in respect of a premises, if I have a caretaker in my tenanted premises, I cannot grant a license to him. I have to
Milord,
be the
that
owner.
would be sub-tenancy, Milord, as per the
So,
definition
No,
which
no,
goes.
something lesser than tenancy I can't grant. Then when you go back home, Mr. Chatterjee, your cook will evict you. Or rather get an injunction against you. We don't know whether he has already obtained it from some. You cannot go back home. You're telling you. It will be a dangerous proposition if only the owner can give a license.
Now, Milord, the definition and the Milord section which says, Milord, to
Just
be a
leave home for the vacation and come back and see what happens.
Now, Milord, in
that
that
is
case,
an
Milord,
absurd proposition.
Milord, that case, Milord, I am the, not my father and mother is the owner, I am better protected there.
Yes, but even if you are the owner, your father cannot go out then. In fact, he is at risk from you also. That cannot be a proposition. And
Now, Milord, kindly appreciate
read
this
out.
definition. Milord, the Honorable Supreme Court,
read out.
Milord, section 52,
Yes.
Milord, is the definition of license, where one person grants to another or to a definite number of persons a right to do or continue to do in or upon the immovable property of the grantor something which would, in absence of such right, be unlawful, and such right does not amount to an easement or an interest in the property, the right is called as licensee. License.
Why should he be a owner?
Now, Milord, 53 qualifies that. 53 says, who may grant license? A license may be granted by anyone in the circumstance and to the extent in and to which he may transfer his interest. This is where, Milord,
His interest, not
his
ownership.
interest in the property
This is a
affected by
lesser
the
bundle
license.
of rights. It can be a lesser bundle of rights.
Lesser bundle, Milord, as on that day he has no.
Whatever interest he has, he can.
Now, Milord, he claims his right by
possessory interest, he says.
Now, Milord, that
As per his
possessory
case.
interest, Milord,
Parted with a part of that possessory interest in your favor. That is his case.
yes, Milord, on that day, if I take it, Milord, he had
His plain case is that he was in
he
possession.
was in possession. Milord, he granted me after purchase. Milord, the
Not after purchase. He does not say that, Mr. Chatterjee. He says that brother and
yes,
sister,
Milord,
they were he was there in
he
possession.
was there in possession.
Before his purchase, he was there in possession.
Correct.
And that ultimately it was sold to him.
Correct.
Them rather, brother, sister. And before that sale also, he inducted you.
Yes, that is his case.
That is his
and
case.
he becomes owner in
He
2005.
was he was in possession. He had a possessory right. He parted with part of that in your favor.
But Milord, his
He can
evidence
do
is
that under
otherwise.
section 52 and 53.
Milord, his evidence is otherwise. He says, Milord, he was never in possession. Milord, after purchase, he became in possession. So, Milord, this is
That is beyond the scope of a licensee or a tenant to look into. You cannot reopen that.
otherwise, what happens, Milord? His plain case, Milord, I was in there, Milord, by virtue of his permission being granted. Now, Milord, if from evidence it is apparently clear that he, Milord, says that I came into possession only after purchase.
That is the difference between preponderance of probability and beyond reasonable doubt, Mr. Chatterjee. We cannot go by clinical precision in a civil case. We have to go by the preponderances of probabilities. They say they were in occupation. That's a plain case, and they you, as far as your status is concerned, you rely on the document which they produced, which is a license patra. It's mentioned as a license patra.
Yes.
So we'll go by that also.
Now, Milord, to this, Milord, I can only, Milord, support my argument by the Supreme Court saying that one has to be the owner. Milord, if a lesser right is also, Milord, is considered, Milord, as per the provision, Milord. Supreme Court considers 52 and holds that. Now, my lord, even if lesser, my lord, what lesser right he had in 2004, 7 except possession? My lord, better title, my lord, in my respectful humble submission, one has to show better interest, if I put it in that way. My lord, possessory interest is no interest, because under the Transfer of Property Act, even an agreement for sale.
After the
doesn't-
purchase, he had better interest.
So, my lord, in 2005, my lord, what at the time of induction?
So what? How does it matter? When he filed the suit, he had a better interest than you. And he files an eviction suit
My
and
lord,
gets a
my
decree.
my
Where
only
is the harm
condition
in
is
that?
at the court, while looking at the eviction of a suit for licensee or a tenancy, my lord, one has
When
to.
the suit was filed, he had a better interest and he got a decree.
Yes, my lord, but
What is so
induction, my lord,
imperfect in that?
at the time of induction,
Induction is immaterial.
my lord, license
The
would
point
be
of filing of the suit is material, Mr.
my
Chairman.
lord, license, my lord, my humble submission, license would be determined on the date when I was inducted. My lord, not subsequently.
It was a license from the license portal, it seems so.
My lord, then illustration A covers my case.
We'll look into that. The present appeal has been preferred by the defendant in an eviction suit against a judgment of affirmance, whereby both the courts below granted eviction on the premise that the defendant stroke appellant was a licensee in respect of the suit premises. For sub next para, learned counsel appearing for the appellant cites such and such reported at 2011 3 SCC 710 in support of his proposition that if exclusive possession of a property of an immovable property is given to a person, comma, the same, comma, although captioned as a license, comma, tantamounts to a lease. Full stop. Next para. Learned counsel further submits that as per the plaintiff case itself, comma, the plaintiffs stroke respondents became owners of the property by virtue of purchase from the original owner in the year 2005, comma, to be precise, on November 29, 2005, whereas admittedly the license was granted by the plaintiffs to the present defendant stroke appellant on August 1, 2004, comma, which is evidenced by a within double inverted license potro, PATRA, double inverted close, exhibited by the plaintiffs themselves. Full hence, comma, as on the date of induction of the defendant stroke appellant, comma, the plaintiffs were not owners of the property, and as such, comma, it is submitted that the plaintiffs did not have locus standi to evict the defendant. Full next para, learned counsel further submits that the factum of exclusive possession being transferred in favor of the defendant is borne out by the license patro itself, comma, which was exhibited by the plaintiff's respondents. For sub next para, secondly, comma, it is contended that there was a misdescription in the schedule of the sale deed by virtue of which the plaintiff's respondents allegedly purchased the property. For sub next para, in terms of the said schedule of the sale deed, comma, it transpires that the plaintiffs only purchase a portion of the suit property. Fusab, it is argued by learned counsel for the appellant that that unless the plaintiffs proved before the learned courts below that the plaintiffs became owner of the particular portion of the property where, in respect of which license stroke tenancy was given to the defendant, comma, the eviction suit could not be decreed in favor of the plaintiffs. Full stop. Next para, the learned courts below, comma, it is submitted, comma, bypassed the issue by relying on certain judgments, by certain precedents, which pertain to incorrect description in the schedule of the plaint.
I bought those decisions.
You go by your of the plaint, comma, in contradistinction with discrepancy in the schedule of the very purchase deed of the plaintiffs themselves. Full stop. Next para, it is contended, comma, thus, comma, that the learned courts below overlooked such aspects of the matter, and as such, the judgments ought to be interfered with. Full stop. Next para, a perusal of the uh, judgment cited by the appellant, that is BPCL versus Chembur Service Station Supra, comma, shows that the proposition for which the same has been cited is not apt to the circumstances of the present case. Full stop. In paragraph number 17 of the said judgment, comma, relied on by the appellant, comma, the section 52 of the Easements Act 1882 was quoted. Full stop. Supplementing the same, comma, the Honorable Supreme Court observed that the definition of license, double inverted license, makes it clear that a license granted by the owner enables a licensee a right to do or continue to do certain specified things or in or upon an immovable property. Full stop. In illustration A at paragraph 22 of the said judgment, comma, it was recorded by the Honorable Supreme Court that an owner of a property enters into a lease thereof, but to avoid the rigors of rent control legislation, comma, calls it a license agreement, comma, in which circumstance, comma, it was held, comma, since exclusive possession was given to the person concerned, comma, the quality and nature of the rights in respect of the premises would be that of a lease or a tenancy and not that of a licensee. Full stop. Next para. However, comma, the contention of learned counsel for the appellant, comma, by placing reliance on the above judgment and sections 52 and 53 of the Easement Act, comma, that that for grant of license, the licensor has to be the owner of the property, cannot be accepted. Full stop. A license can be granted by persons having different shades of rights in a property, comma, which may form the entirety or a part of the bundle of rights associated with ownership of a property. Full stop. There may be various shades of rights of a person in respect of a property, which start from absolute ownership down to a rank trespasser. Full stop. Next para. Such continuum there can be some discrete discrete point in such continuum of bundle of rights which may form a license. Full stop. Next para. In the present case, comma, as on the date when the license was allegedly granted, that is in the year 2004, comma, the plaintiff's respondents were not owners of the property, but as per their plaint case, comma, were in possession of the property, comma, thus having lesser rights than an owner, but possessory rights. Full stop. Next para. According to the plaint case, comma, such possessory rights were parted to an extent in favor of the defendant. Full stop. Next para. Thus, comma, even the Supreme Court, comma, in the side reported judgment, comma, did not lay down the proposition that for grant of a license, a person has to be an owner. Full stop. Rather, comma, the Supreme Court was considering a situation where a license is granted by an owner and proceeded accordingly. Full stop. Next para. Thus, comma, the propositions laid down therein do not have any direct bearing on the present case. Full stop. That apart, comma, exclusive possession, comma, even if given, comma, is not the sole indicator of a license, of a lease as opposed to a license. Full stop. Next para. In the present case, comma, no external aid or vague legal principle is necessary to interpret the document which was labeled as a license patro and formed the core CORE of the rights of the defendant in respect of the suit property. Full stop. A copy of the same is handed over in court today and is kept on record. Full stop. We find therefrom that the said document, comma, in Bengali vernacular, comma, was captioned as a double inverted license patro, double inverted close, full stop. Next para. We have to be careful while interpreting the even the caption of the said document, comma, since, comma, as there is no exact counterpart of license, double inverted close, in Bengali as opposed to tenancy, comma, the author of the document carefully captioned is as a license patro as opposed to a double inverted bharatiya, double inverted close, within bracket tenancy, bracket close, agreement. Full stop. Next para. That apart from, comma, from the said document itself, it is clear that the jural relationship between the parties was claimed to be a permissive occupation. Full stop. The plaintiffs, comma, in the said document, comma, state that no, sorry, plaintiff's in the said documents, comma, the licensor states that they are the owners and occupiers of the property, and that permission was granted to the present defendant to uh, use the said property, is the suit property, for the purpose of residence. Full stop. The document was mentioned as a license document, a license agreement, and the occupation charges payable was also captioned as a license fee. Full stop. Next para, read in context, comma, the said read in context, comma, one of the plausible interpretations in law would be that the said document created a license, full stop. Since both the courts below arrived at a concurrent finding by construing the same as a license document, comma, we, comma, in second appeal, comma, do not find any scope of interference with such factual finding. Full stop. Next para, insofar as the purported misdescription in the schedule of the deed is concerned, comma, such misdescription, comma, even if taken to its fullest, comma, would comprise of a transfer in respect of a portion of the suit property in favor of the plaintiffs, which, comma, in any event, comma, would at least make the plaintiffs co-owners in respect of the same. Full stop. It is well settled that in a suit for eviction of licensee, comma, the plaintiffs have merely to show better title than that of the defendant. Full stop. While ascertaining so, comma, it is not the point of inception of grant of license, but the date of filing of the suit and the decree which are to be taken into consideration. Full stop. As on the date of filing of the suit, comma, the plaintiffs had already purchased the properties and were owners of the property, comma, either in its entirety or portions thereof, and thus were at least co-owners of the property. Full stop. As opposed thereto, comma, apart from the license agreement, comma, the defendant stroke appellant could not show any proof of tenancy being granted to the defendant. Full stop. Next para. Hence, comma, we do not find why such minor misdescription in the plain schedule would be germane insofar as the eviction suit is concerned. Full stop. Next para. It is well settled that in order to get an eviction, comma, the plaintiffs have merely to show that they have a better title than the defendant. Full stop. As opposed thereto, comma, the defendant is to show that the defendant has some right in support, has some right to occupy the premises. Full stop. There can only be certain types of rights of an occupier in respect of a premises, comma, the primary ones being ownership, comma, tenancy, comma, and or permissive occupation. Full stop. It is trite law that in the event either ownership or tenancy is failed to be shown by the defendant, comma, it would automatically be construed that the defendant is either a trespasser or a permissive occupier of the property. Full stop. Permissive occupation is writ, WRIT, large in the document which was produced before the court below, that is the license patra. Full stop. Hence, comma, we do not find any illegality in the findings of both the courts below that the defendant was a permissive occupation and the plaintiffs, comma, who were owners as on the date of passing of the decree and the institution of the suit, comma, had better title and were entitled to get an eviction of the appellant. Full stop. Thus, comma, we do not find any substantial question of law involved in the present case, and accordingly, SAT 265 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, you have got any application, Mr.
Yes, yes. There is an application, Lord. Can
one must be
one.
very well. Consequentially, can such and such is dismissed as well. There will be no address to cost. Sorry, Mr. Chatterjee. এগুলো সব আচ্ছা এইটা ওনাকে ফেরত মিস্টার চ্যাটার্জি প্লিজ এনশিওর দ্যাট আ কপি ইজ পুট অন রেকর্ড এন্ড দিস উই আর কিপিং
Yes. এটা কপি করে প্লেন্টের
বাট এনশিওর দ্যাট ইট ইজ ডান ওটা ঢোকালে উনি ঠিক আপনি ঠিক
দেখি
জায়গায়
জেরক্স
ঢুকিয়ে
করে
দেবেন যে কপিটা দিয়ে
বই বার
ইয়েস মিস্টার মাহাতো better case or worse case?
Better.
Better.
This judgment of reversal.
Acha.
Plaintiffs are the appellant before your lordship.
Other side.
No.
Plaintiff's appellants.
Plaintiff's appellant, my lord, trial court decreed the suit in my favor.
Eviction suit.
Yes. No, it is to suit for declaration of right title interest and injunction. My lord, the learned judge in the appellate court, so far my understanding, my lord, the learned judge in the appellate court has made out a third case, which is admitted by both the parties in their pleadings, in the plaint and written statement. The learned judge has said that my predecessor had not acquired the property, entire property, as per our pleading, when the defendants have admitted such case. This is the first point. And my lord, since the learned judge has made out a third case, my lord, it is also another point, my lord. My lord, original owner was Santobala Dasi. She transferred the property in 1932 in favor of Satkori Dasi. My lord, there are two plots. CS plot number 822. It is, my lord, 53 decimals. And my lord, another plot is 824, which is 1.56 acres. My lord, Santobala transferred to Satkori. Satkori transferred in favor of three persons, Sochidulal, Khitis, and Photik,
Yes.
by virtue of a registered deed of sale of 1932. My lord, these deeds by Satkori in favor of Sochidulal has not been produced. The learned judge in the appellate
Separate portions were given to them. Demarcated portions
No,
were
no,
sold to them.
no.
Jointly.
Joint.
Then one deed.
One deed. It is, my lord, deed number 973 of 1932.
Deed number was given, but deed was not produced.
Yes. My lord, the plot number 822, it is 53 decimals, and 824, it 1.56 decimals. Acres.
So
Now,
both
my lord,
comprise of the subject matter of the suit.
no. Subsequently, my lord, the suit property, this property was
822.
taken by in West Bengal Estate Acquisition Act 1953. Some portions were vested, and under section 6, my lord, some portions were retained. That was, my lord.
Those cover both 822 and
Yes. My lord, both 822.
Yes.
It is, my lord, 11 was retained.
Yes.
Out of, my lord, 53 decimals, 11 decimals were retained, and 824, instead of 156, 149 was retained. Therefore, the three persons, Sochidulal, Khotik, and Photik, Khitis and Photik, they, my lord, got this property.
So they sold to
retained
you. They sold to you.
They sold Motilal Rai.
Then
The name was recorded in the name of Motilal, the exhibit 5. My lord, up to this, there is no dispute. In the written statement, they have accepted this pleading of the.
Motilal sold to you.
No, Motilal sold to my lord Kanailal. Kanailal sold it, rather it was returned to Narayani and Khitis.
Achha.
Then, my lord, Narayani transferred her half portion in favor of defendants number 1 to 9 by two deeds. By one deed 1 to 8 and another deed defendant number 9. My lord, I have got the property from Khitis, half portion. Therefore, my lord,
Demarcated or
no,
not
my lord,
demarcated?
it is not demarcated.
Very good.
Therefore, my lord, I have got out of 11, 5.5 decimals of land. And my lord, in plot number 824, I have got 75 out of 1.49. Half. In the record of rights, my lord, so far 824, instead of 75, 70 has been recorded. But so far as 822, 5.5 decimals had not been recorded. Entire property has been recorded in the name of the defendants. But I filed the suit for declaration, relying upon all these exhibits and documents. The only
It was
deed,
not exhibited.
the deed of 1932 has not been produced. But the court has come to a conclusion.
But unless the deed of 1932 is admitted by them, they also don't have title.
Yes. My lord, admission is better than, my lord, proof.
Look, it's worse than that for them. They also won't have title here.
Their share will also reduce.
Go.
Yes. My lord, it is, my lord, if your lordships kindly come to
No, where is the finding of the
Yes,
appeal?
yes, yes. Therefore, kindly come to
We cannot blame the learned appellate judge because we are also short of space while noting down the. So we could understand the plight of the learned appellate judge, and they work in much worse conditions. We are in AC rooms and all. They have torn carpets and working without toilets. You can very well feel for the judge.
my learned friend was saying, my lord, that he could not understand anything.
No, because it's very difficult for them to work there. Mr. Mahato, you know how they work in the district courts, and in that situation,
Yes,
this timeline and this family tree or whatever, this transfer tree,
again,
it is a jungle actually,
transfer.
not a tree. So where is the findings? Was the finding, and we are
Yes,
convinced that
kindly
it is
come
sufficiently
page-
complicated to admit.
Page 11 of the
Yes.
appeal court's judgment,
Yes, we are there.
paragraph 17.
70. That is page 13.
Well,
Oh,
top
acha, it's the
13, at the bottom it is
pagination, yes. Wait. Para 17, yes.
para 7. Now it is to consider whether the vendor of vendors, that is my lord Satkori,
Hmm.
of exhibit 13 deed, exhibit 13 is my deed,
Hmm.
had valid transferable right title interest to transfer plot number 822 having total area of 53 decimals and plot number 824 having total area of 1.56 acre in favor of the vendors of exhibit 13 deed. That is in favor of Sochidulal, Khitis and Photik. It is already noted that the plaintiff did not submit the deed of 1932. Respondents being substituted plaintiffs produce certified copy of CSROR Khutian number such and such. Original suit plot numbers 822.
Ultimately, court comes to the finding that Satkuri had 3/4 share.
Yes, that is my lord, third case has
But
been
that is
made up.
more than, half share.
No, Satkuri has the entire property.
Acha.
According to us, my lord, by the plaintiff and the defendant, Satkuri has the entire property.
Satkuri's, the subsequent deeds all record that.
Yes.
This is one aspect. And what is the other point taken by you?
Well, this is the only point whereby in the next page,
Yes.
if your lordships kindly come to.
So the second point is same, the third case.
Yes, third case.
This appeal will be heard on the following substantial questions of law. One, whether the learned judge of the first appellate court substantially erred in law in reversing the decision of the learned trial judge by observing that the chain deed of one of the predecessors in interest of the plaintiffs did not have sufficient title to transfer, comma, thereby vitiating the title of the plaintiffs, comma, by overlooking that the said predecessor by overlooking that even the defendants claim their title through the said predecessor in interest in the chain of title, and it was nobody's case that the said predecessor within bracket namely Satkuri bracket closed did not have sufficient title to transfer. Next, Roman 2, whether the learned judge of the first appellate court erred in law in making out a third case beyond the pleadings of both sides in reversing the judgment of the learned trial judge. There's no scope of any interim order. Injunction you may have, we don't.
Yes, I have prayed for that.
What are you enjoying injunction in the court below? Do you have any idea? What is the injunction sought?
Well, not to transfer, not to change the nature and character.
Your possession, is there any finding regarding your possession? Will grant regarding transfer alienation and
record of rights are there.
that may be disputed. Will grant transfer injunction regarding transfer and nature character. You are appealing for all the only one. Yes, there are several respondents.
Both are
No, you are appealing for whom?
All the respondents, substitute respondents also.
All the respondents. Pro forma, we are dispensing with the state. Can one of 2023 ever have? In view of a sufficient prima facie case having been made out and there being urgency involved, as well as the balance of convenience and inconvenience being in favor of grant of injunction, comma, the respondents one the defendant stroke respondents and or their men and agents are restrained from transferring, alienating, and or encumbering the suit property in favor of third parties and or from changing the nature of character of the suit property in any manner till disposal of the appeal. Full stop. Can 1 of 2023 disposable? Can 1 of 2023 is disposed of accordingly without any order uh, of costs. Full stop. Service on the pro forma respondent in respect of both the application and the appeal are dispensed with. Full stop. Next para. In view of the defendant stroke respondents being represented by their learned advocate, comma, service of notice of the appeal on the respondents is also dispensed with. Full stop. The appellants shall put in the trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. First of liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Yes, any difficult things about it?
There was another application for appropriate order.
Oh, we'll have to dispose of that, otherwise the appeal won't be heard. সেটা appear করতে হবে?
It has been
No, no,
already, it has
some other matter, you're confusing with some other.
26th of June 2023. it has been.
আরো আছে? Can 2 আছে?
Can 2 has already been disposed of.
Already disposed of.
It is, my lord, on 26th of June 2020.
Disposed of. We'll take up the next matter.
ওটা তোমার সাবস্টিটিউশন ছিল।
My lord, I am a petitioner in person,
In person.
and
Correct.
this is the affidavit of service.
Are you an advocate?
No, I am a law student as well
Last-
as.
Correct. Yes, yes, on the last occasion.
Yes, my lord, could I brief up the case a little bit?
Absolutely. What is the challenge against? First, tell us that.
The
Injunction
challenge
order.
is against then the injunction order that was passed in the year 2022, and there is a very valid reason for delay why I am filing this appeal. But before I provide the reason of the delay, my lord, I just wish to give a brief case background. It won't take much
1
time.
minute. If there is an application for condonation of delay,
Yes, my lord.
we
it
have
is
to
there.
hear that first before hearing the merits of the matter.
Yes, my lord.
You just satisfy us on the section 5 first.
My lord, the actually a show cause notice, actually the reason was caused due to reliance on an interim High Court order of expeditious disposal passed by Honorable Single Bench.
You want to say something?
No, no, let him
Take your
complete.
seat.
Directing the trial court to dispose of the injunction on urgent basis within 1 year, starting from December 2003,
Yes.
granting final opportunity to file to the respondent to file written objection on the injunction application. That is the show cause order that was issued, and it is enclosed with the condonation of delay application. My lord, over here the delay was not willful but arose out of a bona fide belief in procedural compliance of the trial court. Now your petitioner acted immediately when the time limit has crossed, that is December 2024. I acted immediately by filing this appeal on injunction show cause order because
Appeal period is 90 days.
yes, I'm stating
So
the
when the-
reason for the delay.
Yes, but we can't understand the reason. The order was passed on March 2nd of March 2022.
Yes, my lord.
You should have filed by say April, May, June.
I was waiting because there was an interim order in between of expeditious disposal. That's the reason I cannot file the appeal.
Why can't you file an appeal for that?
What
does it have to do
the
with the-
honorable single bench specifically stated providing respondent a final opportunity to file written objection on the injunction application.
You have challenged the ad interim order of injunction in this appeal
Yes, because
during
there,
pendency of the injunction application.
yes,
Do you know the difference between an ad interim order and a temporary order?
it's just a status quo.
During pendency of the injunction application. No, it may not be a status quo also. Ad interim is when you first get an injunction, when the injunction application is moved, from then for a limited period or till the disposal of the injunction application, that is called an ad interim order. And when you get the injunction application disposed of, you get a temporary injunction order. You have challenged an ad interim order or the injunction application was disposed of finally?
The application was filed for an injunction and in the year 2022 on 28th February.
What are you challenging, an ad interim order or the final disposal
It's
of the
not
injunction?
the order I'm challenging, my lord. Please let me brief a little bit.
No, don't brief us. We are not here to be briefed by you. We are
And
asking questions, please answer us. You are challenging an ad interim order or a final disposal of injunction order?
It's a show cause order of an injunction.
We
That
don't
was not
find
heard.
any reason for the delay. We don't find any
That was
reason
not heard till date, my lord.
that. Why should that give you a furnish you a ground for filing an appeal? You should have filed the appeal long back,
But
3 years back, in fact.
But the delay was not willful. I was
What
stuck. I was stuck in the.
Stuck means you are fixed to the trial court's chair by a glue.
I was stuck for the. For
An
the
order is passed, you have a right.
disposal order.
What does that have to do with your appeal? We absolutely fail to understand, Mr. You are Mr. Sarkar, Mr. Das. Mr. Das, you fail to understand this. An injunction is passed against you, you will prefer an appeal within 90 days. The court has directed the suit to be heard out expeditiously, let that be done. So how does that prevent
But
you from
that
preferring
has
an
not
appeal?
been done, and
That is a different
not
proposition.
a single order has been passed
Maybe.
on that case till date, my lord.
Maybe. For that, you
My
have
lord,
you move for implementation of the order of the learned single judge. You should have moved before the revisional court, taking up to 27 matters and point out that your order has not
my
been
lord, I
complied with.
moved over there, but that was not heard.
What can be
I
done?
moved over there. I filed a review
Sorry, we are
petition
rejecting the
as well.
Section 5
I
application.
filed a review petition as well, but that was
Maybe.
not heard.
We are
My
rejecting
lord,
the
it
Section
is
5.
just an inherent power to invoke the inherent to secure the ends of justice.
Yes, that inherent power does not lie with us, the appellate bench. The appellate court's power is very limited. We have to see first whether the appeal is in time. Secondly, if it is in time, what is the scope of that order? We cannot go beyond that. The learned single judge having 227 power, 227 is the superintending power, Mr. Das, not order 43. Order 43 were not exercising superintending power.
But my lord, I am not
You
here.
complain before this 227 court and say that your order is not being complied with. Do that. You are absolutely at liberty to do that. The present appeal has been preferred against an ad interim order dated March 2, 2022. Full stop. Learned. No, the petitioner, the appellant stroke petitioner, comma, appearing in person, comma, submits that the appellant was under the impression that a direction given by a learned single judge of this court on September 13, 2023 in CO number 2512 of 2023, comma, asking the trial court to expeditiously dispose of the suit, comma, would be complied with, full stop. However, comma, the same has not been complied with by the learned trial judge, full stop. It is submitted by the appellant stroke petitioner that since he was under the presumption that the order of this court would be complied with, comma, he did not take any steps to prefer the appeal, full stop. However, comma, since the said timeline stipulated in the order of the learned single judge was not complied with, comma, the appellant was prompted to prefer the present appeal. Full stop. Next para. However, comma, upon hearing learned counsel for the parties, hearing the appellant appearing in person as well as the learned advocate for the respondent, comma, we are unable to convince ourselves as to the sufficiency of the reasons of the huge delay of about 1041 days in filing the appeal. Full stop. The remedy of the appellant, comma, in the event the appellant was aggrieved by the delay in disposal of the injunction application or the suit in the court below is absolutely unrelated with the present challenge against the ad interim order itself. Full stop. Such remedy against the inaction of the trial court, comma, if any, comma, would lie by way of a proper application or a complaint before the court taking up jurisdiction matters under Article 227 of the Constitution of India. Full stop. Next para. However, comma, such inaction, comma, even if any, comma, does not furnish a defense for the huge delay in preferring the present appeal. Full stop. The present appeal has been preferred against an ad interim order, comma, the timeline for preferring which was 90 days from the date of the order. Full stop. As such, comma, we do not find any reason being shown by the appellant for the delay in preferring the appeal. Full stop. Accordingly, Can 1 of 2025 is dismissed on contest without any order as to cost. Full stop. Consequentially, FMAT 32 of 2025 is dismissed as time barred. Full stop. Accordingly, Can 2 of 2025 stands dismissed as well. Full stop. There will be no orders to cost. প্রথমেই করে দেবেন, affidavit of studies filed to be kept on. Sorry, Mr. Das.
No problem.
You tried your level best, but
No problem.
next.
I beg to appeal for the appellant here, my lord.
Yes.
The second appeal, my lord, I challenge an order of reversal of a decree of declaration and injunction. Now, my lord, if I place, my lord, the facts, my lord, the background of the case.
You are the plaintiff.
I am the plaintiff.
Got the decree, but reversed by the
It was reversed.
declaration of your title.
Declaration of title and interest. Now, the property concerned had flown to me through, my lord, certain, my lord, devolution, my lord, ancestral devolution, and a part of the property had also flown to, my lord, the predecessor of the defendant or of the respondent here. Now, in 1955, a partition suit was filed. In 1955, 1956, the partition suit was, my lord,
Partition
finally
suit between the predecessors.
Between all the owners, all the co-owners of the property, which is a number of persons, my lord, since the DAG number was same. Now, my lord, in the partition suit culminated in a decree.
1 minute. There is only one pro forma defendant.
Yes. Now today there is the dispute has come down to this only. There is only one pro forma defendant. Others are not recorded because the partition suit, my lord, has, my lord, distinguished the properties.
No.
We are all in.
The present suit was filed against this
Against
respondent
only, yes, only this defendant.
So why was it described as a pro forma defendant? He has been described in your cost title as a pro forma defendant.
It is not. It is not. It is the actual respondent. This is the only respondent.
He's the only respondent.
This is the only respondent.
This is a mistake. I mean,
I'm sorry, my lord. Perhaps, my lord, in the plain, my lord, plain petition number 3 was also a respondent. But I'll just check up and
there should have
clarify
been proper
this.
description in the
Yes,
cost
my lord.
title, because otherwise they'll, if it happens that
It is not pro forma. It is not pro forma. In the plain, it is
this
also
cannot be
it-
pro forma, that we are sure. But regarding the appellants, if they were in different capacities in the court below, you have
They
to
are
say that suppose one and
I understand.
you know that
I understand.
plaintiff's appellants and the
That is
other
not the
one
case here.
former defendant stroke appellant.
That is not the case here. my lord.
Anyway, who are you? I mean, you
I am
are,
the plaintiff. I am the plaintiff.
all of you are plaintiffs.
All of us are plaintiffs.
So we'll
Three
just ignore that
petitioners are
pro forma
plaintiffs.
part.
Yes, the pro forma should be deleted and should be on
There was a
respondent.
partition, there was a partition decree in that partition.
Partition decree on a solenama decree by compromise.
Then
Now, my lord, by compromise, a portion of the property which was clearly distinguishable was given to me. I was in settled possession of the property, and all the other defendants, in terms of the solenama decree, were in settled possession of the property.
all
Now,
the other defendants there.
there in that partition suit, they were all in settled possession of the properties. Nobody is now creating any disturbance. This defendant only, this respondent only, has come up after, my lord, almost 50 years of time, and, my lord, trying to claim my lord, joint rights over the property which lies in my favor. Now, my lord, if I may draw your lordship's kind notice to the decree.
Why was it reversed by the appellate?
It was reversed, yes. If I may,
So why was it reversed? Just tell
it
us.
was reversed by saying, my lord, that my lord, the jointness of the property continues, despite holding that, my lord, from the solenama decree, that a particular portion starting from a particular point was given to the plaintiff. That was held, and thereafter it is held that the jointness continues. If I may just point out, my lord, straight to the appellate decree.
Better.
Let me invite your lordship's kind notice, my lord, to page 55. The appellate decree, my lord, starts from page 46. And if your lordship kindly comes to page 55 first. I'm sorry, I'm referring from the application. If your lordship
Yes,
takes
yes,
up the appeal, it is at interim page 10.
Very good. Yes.
Interim page 10, my lord, second paragraph.
Yes.
Your lordship kindly finds at the time of writing judgment, this is where, my lord, the reasoning starts. This before, my lord, all the facts are laid down.
Right.
At the time of writing judgment, learned trial court reached to the conclusion that by virtue of compromise decree dated such and such, in TS number such and such, in between such and such persons as plaintiffs on one hand, and Karim Bucks, this is, my lord, the predecessor interest of the respondent, and others as defendants on the other hand. The suit property being 14 decimals of land in plot number such and such was allotted in favor of Siddika Bibi and Samiran Bibi, my predecessor interest. On the basis of the compromise decree, learned trial court holds that predecessor of the plaintiff got suit property by strength of that compromise decree. Next paragraph. Now let us scrutinize the compromise decree passed in such and such. From the decree, it appears that plaintiff of the suit, that is such and such, got properties described in schedule of the compromise petition. In that schedule, it has been written as out of 53 decimals of land, 14 decimals of north allotted in favor of Siddika and Samiran. There is no specification in regard to rest 39 decimals of land. It has mentioned in the solenama that rest property distributed among the defendants according to their share. No specification has been mentioned as regards the portion of the defendants, but it is clear that the defendant number defendant Karim Bucks also had share in the suit plot. Though it has not been mentioned where his share is situated. This is all what the learned appellate court finds, and thereafter goes on to hold at page 11.
No, in the previous solenama decree, there was a preliminary decree only.
Lord, this decree is not with me. It is stated here that it is a preliminary decree, but my humble submission, even considering this to be a preliminary decree, if the shares are determined, if the shares are determined,
What would be disposed of finally? Where is the question of a final decree?
Suit is disposed of. The petition
was
suit was disposed of. Yes.
But that solenama decree must have been exhibited in the court. Without that, how are you moving that?
That is exhibited. That is from the exhibit that the learned appellate court is finding, and the learned trial court also found. The solenama decree is exhibited in the learned trial court. It is not with me right now.
But court says in page 12, internal page 12, appellate court, third paragraph, it is fact that from solenama decree, it appears your predecessor got right over 14 decimal, and admitted position is that predecessor of appellant even was also co-sharer of suit plot number. The 1910 was the entire plot.
1910 was the entire plot, which comprised of much larger than 14 decimals.
Solenama decree you have not annexed.
That is not annexed in my petition. That was not with me while
You have
filing
a
petition.
copy
I
with
can.
that now.
I have
Was
obtained
there?
a copy. I have obtained a copy.
That is
Lord,
the only document we have to look.
That is the only document. Perhaps Lordship will have to look at.
How could you draft the appeal without that? Guesswork.
Lord, I drafted the appeal only on that paragraph.
Don't do this. The Solenama degree is the first thing you should have had in your hand, even before these judgments. Your consultation should have started with that Solenama degree.
That was acquired later after filing of the appeal.
Understood. That is the order of the day. You are not an exception. We are also doing it in our judgments. Before coming into court, you should have the 2 copies of the Solenama degree at least cut and dried in your hand for the judges.
And then একটা copy. One. আর একটা copy. Lord, this is the Solenama decree. May I also hand up my copy? There is only one.
Your copy will go to Justice Kumar
Lordship,
with your back sheet.
kindly excuses me for this.
My brother may call you sometimes because you have the phone number also there.
My phone number is not there. Lord.
Back sheet
Kindly
should
pardon
be
me for
there.
this. Kindly pardon me for this matter. But,
This appeal will be heard on the following substantial question of law. Whether the learned judge of the first appellate court substantially erred in law in reversing the decree of reversing the judgment and decree of the trial court, whereby the exclusive title of the plaintiff's appellants in respect of the suit property was declared, comma, on the premise that by virtue of the original Solenama decree, comma, which formed the basis of the rights of the parties, comma, although the plaintiff's predecessor's share was declared in a demarcated form, comma, the shares of the predecessor in interest of the defendants were not so demarcated inter se. So next para, whether, comma, in view of the admitted position, as evident from the Solenama decree, comma, that the predecessor in interest of the plaintiff's appellants were allotted a specific demarcated portion thereby, comma, the learned appellate court was justified in reversing the judgment and decree of the trial court, whereby the exclusive title of the plaintiff's stroke appellants in respect of the suit property was declared. Any interim?
Also, Lord, if I filed an application, and Lord, on the questions frame, Lord, if also, Lord,
Yes.
if the decree can be reopened, this is a Lord, attempt to reopen the decree of 1956.
No. He relies on that. He has not reopened the decree. He relies on that. He says in that decree, defendants' predecessors
Also,
were not demarcated. Their shares were not demarcated. He does not reopen that.
Yes.
He goes by that. What is the application?
the application is for injunction, Lord, restraining the respondent from invading a
The
public property.
respondent stroke opposite party shall remain, the respondent stroke opposite party and or his men and agents shall remain restrained by an order of injunction from selling, transferring, alienating and or encumbering the suit property in any manner in favor of third parties and or from changing the nature and character of the suit property till disposal of the application, full stop. The parties shall also maintain status quo as regards possession in respect of the suit property, comma, also till the disposal of the application. Full stop. The appellant shall serve a copy of the application on the respondent, indicating that the application shall be listed in the monthly list of July 2025, when an affidavit of service to that effect shall be filed by the appellant.
Deeply obliged. And Lord, the respondent is trying to invade upon my property of specific Lord,
No,
observation.
because regarding possession, we are not sure without hearing them as to which portion you were in possession of. That will be a vague order. Although we have passed a vague order by granting status quo. Even then.
Deeply obliged. Deeply obliged.
Solenama, this is the only copy you have?
That, Lord, I can acquire other copies and Lord, yes. So deeply available. Right.
And I beg to appear for the appellant, my
For the-
lord.
for the
Yesterday, my lord, as per my lord's direction, I have submitted the certified copy in the record, my lord.
Very
And I will only beseech your lordship to take the supplementary affidavit which I have filed yesterday, my lord. And that contains all the orders passed in this matter, my lord. And the order impugned as well, my lord.
All right. You have challenged what?
My lord, I have challenged the order number 19, order to the 2nd April, my lord, which is actually a subsequent order of an ad interim order passed on
Suppose you can take your seat here.
on 26 June 2024. My only ground of challenge before your lordship is that, my lord, that the ad interim order that which was passed, whereby the bank accounts of the appellant before your lordship has been freezed, stating that these bank accounts are part of the succession of the testator, is a suit for, my lord, under Indian Succession Act, my lord. Application under section 127 Indian Succession Act, my lord.
Letters of administration, not.
Letters of administration, my lord.
No. What is this by this order? What has been done?
My lord, with this order, my lord, the bank accounts has been freezed, my lord, by order dated 2nd April. What I am trying to beseech your lordship is that the
Yes.
first ad interim order was passed on 26 June 2024, my lord. My lord, thereafter, the order has not been extended. The compliance on the order 39 rule 3 has not been done, my lord. I can show it from the record itself, my lord. My lord, kindly come to page number 9, my lord. Page number 9 is order number 9, my lord. This is the ad interim order, my lord.
Yes.
On the next page, my lord, it is say, having heard the learned counsel on the application for injunction, this court is inclined to pass an ad interim injunction in terms of prayer B, C, D, E, F, G, and H. The application for injunction be also served upon the heirs as mentioned in paragraph 2. Petition is directed to take necessary steps under the provision of Order 39 Rule 3A and B of the Code of Civil Procedure.
B, C, D, and E also included this freezing of the account.
My lord, my lord. Thereafter, my lord, the matter was again taken up on 25th July. My lord, on that day, petitioner files petition praying for time on ground. No, my lord, on the very next day, on 26 June, the ad interim order was passed. On 27 June, no affidavit of service pertaining to order compliance of order 39 rule 3 has been filed. My lord, thereafter, by order number 11, my lord, the petitioner files track reports. First of all, my lord, order 39 rule 3 has not been complied with. And if my lord goes
How
to...
do we know that? How the appeal is an illusory remedy for you? You should have approached the trial court.
My lord, I have approached on 2nd April, my lord. But the trial court, without even hearing me, has passed this order, my lord.
File a proper application.
I have filed...
Argument has not been recorded that they have not complied with 39(2)(a).
My lord, be that as it may, my lord, the interim order has not been extended as well, my lord. There is no extension of that interim order, my lord. It's an ad interim order. It's an ad interim order.
It was passed till when?
My lord,
no, it was passed indefinitely.
Having heard the learned counsel on application for injunction, this court is inclined to pass an ad interim order of injunction and fix the matter on for hearing of the injunction application.
It was not restricted up to that date.
But my lord, there is no specific mention of that it has been passed till the
ad interim order injunction means ad interim by default means till disposal of the injunction application unless a date is fixed.
My lord,
in trial courts always dates are fixed.
My lord, my date has been fixed on 25th July for hearing.
Date is fixed for up to which that order will operate.
That has not been mentioned. I shall bow down. I shall bow down before your lordship. That has not been mentioned. But my lord, even if I go by record, my lord, by
end of April order is redundant unless the court had disposed of the injunction application itself.
It has not disposed of. Instead, my lord, what has happened?
You have not challenged the 26th June order.
My lord, I have not. I shall bow down before your lordship. I have
that
not.
order remains stares at your face. We can direct. You have filed your objection.
My lord, I have not filed my objection because after 2nd April I have come before your lordship. The matter has not been taken up.
Your objection will give you a week and direct the.
Then, my lord, kindly, because the fact is, my lord, the bank account which has been freezed, saying that these are the estate of the testator, my lord.
Freeze from June 2024.
Yes, my lord. I was not aware, my lord. Now, what has happened, my lord? There are subsequent facts that has happened. At first, it was not freeze, my lord. On 12th March 2025, the learned code
Maybe,
below.
but 26 June it was for 1 year it has been frozen.
No, no, not for 1 year, my lord. It has been frozen from March 2025 because the bank authorities were called for, my lord, because they did not comply with
Might
the
not
order.
have been implemented, but the order stares at your face.
My lord, it
For
does.
1 year the order
It
is
does.
there. You have
It
not
does.
challenged that.
But that, my lord, the bank accounts are of joint holders, my lord.
Whatever. That the merits will be decided unless you put in your written objection. How can that be done? And we don't find any reflection that 39.2 has not been complied with.
My lord, then I shall take you.
That
this
could
just-
have been taken care of by the trial court only on evidence.
Yes, but my lord, let me just take you just to what only one order. I bow down what you lordship on or my lord, page number 15, order number 17, my lord. If I may read it for your lordship.
Yes, 17. Order number 16. Page 15.
17, my 12th March 2000, page number 15, my lord.
Or 15 carries order number 16.
My lord, then the
Then our
subsequent order.
16.
My
Order
lord.
number 17 is the order.
Yes, my lord.
That
Order
is
number
page 16
17.
of our
Yes, my lord.
Yes.
Here, my lord, the bank authorities were called for, my lord, learned count, and the bank authorities have specifically stated that they have not received the order, my lord, within time, which also shows, my lord, that 39(3)A was not complied within the
Not
day.
by default, no. Bank authorities are, their statements are not always sacrosanct.
But my lord,
What
there is no
statements are
reflection,
sacrosanct?
my lord. There is no reflection in the order. Instead, by order number
Therefore,
11.
we'll have to go by guesswork whether they have actually
But my
complied.
lord,
or
if
not.
I even
Look
if
at
I
the
go,
appellate court, that's why we said appeal is an illusory remedy for you. Insofar as this
my
non-compliance
lord,
of 39
I
is,
completely
we
bow
don't
down,
have
my
any
lord.
material
Even
before
that was my suggestion at first, my
Had
lord.
to be your
I
suggestion.
have to seek my
Yes,
remedy over
that
there,
is
my
the
lord.
definition of illusory remedy. Because
My
the
lord.
appellate court
But
wouldn't
my
have.
lord, with regard to order number 11, that is the first time the postal reports, track reports were filed on
Maybe it
19th
has been
September.
filed later, but it was complied with within time. We don't know. We never know. Might
My
have been
lord,
filed
may I,
later.
then may I pray?
Advocate's clerk might have gone home on vacation. We don't know why it was filed later. We have to entirely resort to guesswork. It might be just because the postal track reports were filed later does
It has
not
been filed at
automatically,
least after 3 months, my lord.
automatically does not, we cannot infer that it was not complied with within time. Might have been, the requisites might have been put in within time.
But my lord, for the very next day, it was
Postal receipts are over and above. Two modes. We don't know whether the requisites were put in court. Postal receipts were
but
filed
there
by
is
them.
no order pertains to that.
Exactly. That is
shall-
what we are suggesting also.
My lord, there is
There is
no-
nothing on record.
We have
for
to
us
infer.
come.
I
either
infer,
way.
try to satisfy your lordship.
You also inferred.
Yes, my lord. I tried to satisfy your
To
lordship.
direct the injunction application.
Then, my lord, kindly fix a
How soon
stipulated
can you
time.
file your objection? That
My lord,
depends on
this week itself, my lord.
Don't overdo it. You won't be able to file, then the
My lord, then, my whatever my lord feels right.
Date is on 18th. That is next week.
18th is an then they have to file it with it.
My lord, my lord.
Thank you, Mr. Bose, for that. 18th means yes. Fair enough. Fair. The present appeal has been preferred against an order dated March 12, sorry.
2nd April, my lord.
Right.
Order dated
An order dated April 2, 2025, whereby an injunction has been granted freezing the bank accounts in respect of the estate of the deceased. It was in respect of a will or
My lord,
without.
it was no, without will, my lord. It wasn't without.
In respect
It's
of
an
the deceased
application
in
of-
connection with a testamentary proceeding for issuance of letters of administration. Which of next para, learned counsel for the appellant argues that although an order of injunction, including freezing of bank accounts, was first passed in ad interim form on June 26, 2024, wherein a direction was contained for the plaintiffs to comply with the provisions of Order 39, Rule 3, within bracket small a and small b of the Code of Civil Procedure, the said provisions were not complied with by depositing the requisites in time by the plaintiff stroke respondent. Full stop. Next para. It is thus submitted that the court acted beyond its jurisdiction in virtually reimposing the self-same order by the present impugned order without there being any extension in the meantime. Pusap, it is also sought to be argued that by the initial order dated June 26, 2024, the ad interim order was passed for a limited period and it should be construed that the order expired on the next returnable date. Full stop. However, we are unable to agree with such submissions. Full stop. apart from the fact that the parent order dated June 26, 2024 has not been challenged by the appellant, comma, we also find from the order itself that the ad interim order was passed without any temporal restriction. Full stop. The manner in which the order was couched indicates that the ad interim injunction was passed in terms of the prayers made in the injunction application itself and operated till disposal of the injunction application. Full stop. Thus, comma, there arose no question of further extension, and the order dated April 2, 2025 is merely a reiteration of the parent order dated June 26, 2024, which has not been challenged. Full stop. Next para. Insofar as alleged non-compliance of the order, non-compliance of Order 39 Rules 3 within bracket small a and small b of the Code of Civil Procedure is concerned, comma, we are not equipped enough, comma, as an appellate court, comma, to enter into such question, comma, simply because we are not posted with sufficient materials which will be only evident from the trial court records, comma, as to whether such compliance was actually done or not. Full stop. Thus, comma, as a ground of an appeal, comma, the said contention of the appellant is at best illusory insofar as the appellate court is concerned. Full stop. If any complaint in that regard was to be made, comma, the appropriate forum was the trial court itself and not in appeal. To the next para, be that as it may, comma, instead of prolonging the agony of the parties further due to pendency of litigation, comma, we direct the appellants to file their written objection to the main temporary injunction application within June 13, within June 13, 2025, full stop. No question of replying the trial court, Mr. Bose.
My lord, if there is a rejoinder and
No,
additional,
no, we won't change the practice of the trial. That will open a floodgate.
my lord, I could have earned some fees.
No. The learned trial judge. Now, since we are apprised by learned counsel for the respondent that the next date fixed for hearing of the injunction application in the trial court is June 18, 2025, comma, we hope and trust that the hearing of the injunction application shall be concluded on the said date and final orders would be passed thereon within June 25, 2025. The FMAT 151 of 2025 is thus dismissed disposed of without interfering with the impugned order, but in the light of the above observations, comma, making it abundantly clear that we have not entered into the merits of the contentions of either of the parties in the injunction application as well as in the suit. Can 1 of 2025 is accordingly disposed of as well, no arrest to cost.
Grateful, Lordship.
Grateful.
Suppose we could not record your submissions because we are at the order 41 stage, so we won't go into that rigmarole of admitting the appeal and disposing it of. Then we would have to go into the merits. So we are just. Yes.
Lordship 27, Mr. Taraknath Sarkar is suffering from illness. Kindly, Lordship, not.
Or you seem to be healthy, so you start the matter.
Lordship,
You belong to his chamber.
No.
Then you cannot pray for adjournment. You don't have the right. Unless you have the papers, no adjournment.
Lordship, I am instructed by him.
No, his instructions won't do. We are not bound by his instruction. On the last occasion also, you had there was an adjournment paid for.
Yes, Lordship. Kindly, Lordship.
No.
Sans, Lordship.
What is the nature of his illness?
Lordship, high fever. He is admitted in the hospital. Lordship.
Admitted in a hospital. On the prayer of the appellant, comma, in view of the illness of learned counsel for the appellant, comma, let the matter stand adjourned till when?
Lordship, 1 week.
Taraknath was is
Swatantra ke tarikh diyeche. June 17, 2025. Please give your name, ma'am.
Title number 20, Lordship, I beg to appear on behalf of the petitioner. I am led by Mr. Shobhoshachi Chatterjee. Yesterday, Lordship, your Lordships were pleased to challenge the order of the learned court.
We did not challenge any order. We are admitting the appeal.
Lordship, may I read section 49 from the Registration Act, Lordship?
No, you may read the proviso to section 49. We are convinced because the next matter after Mr. Chatterjee's matter, we were convinced by other counsel in another matter that we were wrong and you were right. Mr. Chatterjee was right. So we'll admit the appeal on that.
Lordship,
We are admitting the appeal. The present challenge has been preferred against the refusal of an injunction application filed by the plaintiff's appellants in a suit for specific performance of contract. No, the suit was not for specific performance.
Lordship, the suit was for the specific performance of contract.
Have you annexed a copy of the plaint?
Yes, Lordship.
Just
Lordship,
application of ভুলভাল লিখেছি. Yes, yes. In your application, you have stated otherwise. Anyway, suit for specific performance of a contract. Full stop. The learned trial judge refused injunction primarily on the ground that the agreement on which the plaintiffs rely is an unregistered one. Full stop. Next para. However, learned counsel for the appellant submits that the proviso to section 49 of the Registration Act clearly stipulates that in case of a suit for specific performance, the bar under section 49 is relaxed. Full stop. Thus, a strong prima facie case for grant of injunction as well as hearing the appeal on merits has been made out. Full stop. Accordingly, we admit the appeal to be heard on the above question and the other grounds taken in the memorandum of appeal. Full stop. You have filed a stay application. Why you should have filed an injunction application? You have not filed an injunction application. You have filed an application for stay of all further proceedings of the appeal of the suit. You are the advocate on record.
Yep.
Why did you not file an injunction application independently? Did you draft this application?
Lordship.
Why didn't you prefer draft an injunction application? Injunction has been refused to you. So if you admit the appeal, you have to grant injunction. You have asked for stay of all further proceedings of the suit. Why should you stay the suit? There is no averment also that they are trying to do something. কি বলবো বলুন তো? Preliminary no, you have asked for stay of some other suit.
Lordship,
Stay of
অন্য সুটে স্টে চেয়েছে
further proceeding of titles of number 41 of
অন্য কোন সুটে স্টে চেয়েছে না এটারই তো স্টে চেয়েছে এসব লিখেছে হোয়াট হ্যাভ ইউ রিটেন এনিওয়ে
এই তো সুটটা আছে সেলফ
এইসব দেখে লেখা You have copy pasted from some partition suit, ma'am. You have stated that after passing of the preliminary decree, they are taking steps for drawing up a final decree. Yes, Mr. Chatterjee, come here. We are waiting for you.
Proviso. I failed to.
That proviso. What proviso? You admitted the appeal. What have you stated in your application? Please give him a copy of your application copy. Please take paragraph 6 of your application, Mr. Chatterjee. We are eagerly waiting for you to step into the trap. Para 6, please read out. Para 6 of your stay application, Mr. Chatterjee.
Yes, my lord, that after passing the preliminary degree, respondent is taking steps.
After passing the preliminary degree, they are taking steps in for drawing a final degree. What did not? Show us one averment regarding injunction. We'll mold the relief. Show us one averment they're trying to do something. What sort of an injunction application? This is a stay application, no doubt on that. You have paid for stay of all further proceedings of the suit. We are not aggrieved with that, but we are rather disturbed with the fact that there is no single averment that they're trying to dispose of. We cannot, even if we want, we can't grant injunction. Sorry.
May only
May you do what? You have admitted the appeal. Now you can do what?
kindly
File an application for injunction. Come back.
I'll file that.
We find from the abatements made in Can 1 of 2025 that the same is misconceived, comma, since there is no scope of stay of all further proceedings of the suit in connection with the present appeal, which arises out of the refusal of an injunction. Full stop. However, comma, the appellants are granted liberty to file an appropriate application for injunction and to mention the same for inclusion in the list as and when filed. Do it immediately.
Great.
Thank you. Abatement to the near affidavit একটা লাইন তো লিখতে হবে এখানে তোমাকে
I'll file it tomorrow.
Do it tomorrow. Yes, Mr. Banerjee. Oh, that matter. Yes.
What?
Lord, yesterday I wanted to place the judgment of the Supreme Court, Lord, with regard to the interpretation of section Article 58 of the Limitation Act.
Right.
Lord, one thing I may candidly.
Sorry, Mr.
Lord,
we are trying to find out some space for your physical space for your
Lordship.
For your emotional argument. আপনি আসুন দীপক। হাত চিপতে যাবে আপনার ডান হাতে গেলে অনেকের সুবিধা হবে এবার বসানোটা কোন Please carry on.
Bulky papers, Lord.
No, not your fault. Not anybody's fault.
Inconvenient for which,
Leads were bulky.
for which, my Lord, I am beg to be excused for that.
No. You are.
But I am not referring those, my Lord.
Mr. Banerjee, what is that?
Yes.
What are you saying?
Now, Lord, your Lordship, kindly look to section 58 of the Limitation Act. Article, sorry, my Lord, Article 58 of the Limitation Act. To obtain any other declaration 3 years when the right to sue first accrues. The language is, my Lord, the first accrues. And then 59, Article 59. To cancel or set aside an instrument or a decree or for the rescission of a contract. When the facts entitling the plaintiff to have the instrument or a decree cancelled or set aside or the contract rescinded first become known to him. Now, Lord, in the case of set aside a decree or in the case of set aside a deed, Lord, then, my Lord, he can plead that it was not within his knowledge. And his knowledge came with effect from the date of taking out the certified copy of the deed or the degree. The test of deciding Article 58 applies or 59 applies, Lord, is the prayer made in the plaint. Whether prayer made in the plaint is for setting aside or prayer made in the plaint is for declaration. Lord, that I have drawn your Lordship's kind attention yesterday. I need not read again. Declaration that the deed of 2012 is a void deed. On the ground that they have no title, that the vendors of the 12 purchasers of 2012 have no title to the property. Therefore, it is a void one. Therefore, my Lord, it comes within the purview of 58. Now, 58 comes, my Lord, because he, according to the prayer, he wanted to, Lord, set aside that, get a declaration that the deed is a void one. Then consequential relief is, my Lord, for setting aside the...
A and B are consequential to C.
Consequential, yes. Entire, my Lord, is consequential because, my Lord, it depends upon setting aside the sale certificate and the registration. If the deed stands, 2012 stands, then this cannot be granted. Therefore, this is consequential.
That is time barred. That is the principal relief. That is time barred. Therefore, suit is not maintainable. No,
and, my Lord, for this, my Lord, they have, Lord, made a allegations, my Lord, in the for the purpose of declaration. Lord, in the plaint, they have made an allegation.
Yes.
For that. Lord, only for that purpose I may place before your lordship the plaint abatements.
Yes.
প্লেনটা কত নম্বরে আছে গো দেখো প্লেনটা প্লেন্ট plain melody in the paper book. Plain in the paper book.
This is not a paper book. This is the plaint itself.
This is the printed. Yes, yes.
You can
Yes,
mistake
yes,
it for
yes.
a paper book.
Yes,
not a
yes,
paper.
yes, my lord. Plain. Lord, lordship kindly come to the আমার এটা কোথায় গেল নোটটা আমার নোটটা Yes, my lord, your lordship kindly come to paragraph 12, page 19. Lord, let us come to paragraph 9. The plaintiff states that upon causing further inquiry, the plaintiff came to learn that by virtue of a sham deed of conveyance dated 16th of March 2012, recorded book number so and so, one so and so, represented by one so and so, the legal heirs of Jitendranath Ghosh and Jibon Ghosh since deceased and Ratan Chandra Ghosh since deceased, who were the original owners of the property, who had sold and transferred their respective shares in the property way back in the year 1964-66, that is more than 40 years ago, to the predecessor interest of the present plaintiff. Copy of the purported deed of the conveyance dated 16th of March 2022 is annexed here 2, marked with annexure T. Then lordship kindly come to 12. The plaintiff states that the defendant number 2 thus made purported purchase the suit property not from the then registered and recorded owners of the suit property, that is Radhika Pala Ghosh, owner of the 3/4 share, and Kitish Chandra Ghosh, since deceased, owner of 1/4 share, but purchased the same from persons who are a stranger to the property, who had no right or interest or ownership in the suit property in the year 2012, when the purported purchase was made. The plaintiff states that the defendant too had the means of discovering the truth with the ordinary diligence, and as such, it is clear, means to discovering the truth with ordinary diligence, and as such, it is clear that the defendant number 2, in collusion with Arjun Singh and the legal heirs of the said so and so, since deceased, and Ratan Chandra made procured the alleged deed of conveyance dated 16th of March 2012 of the suit property, fraudulently knowing fully well that it did not, as it could not acquire any right over the suit property or any part or portion thereof. The plaintiff states that the suit property could not have been formed part of the assets of the MPS group as wrongly and illegally done by the committee without making any inquiry whatsoever in this regard, but mechanically including the suit property in the list of assets of the auction notice based on the sham deed of conveyance of 2012. Therefore, my lord, this is the cause of action pleaded in their plaint, my lord, based on then, my lord, paragraph, my lord, 14, lord, last sentence, page 21. The defendant number 1 solely relied on the 2012 deed, which was void ab initio for being sham. The defendant number 1 thus is not a bona fide purchaser, cannot claim any equity nor claim title by virtue of the said auction conducted by the committee. Now, Lord, 2012 deed, transfer 2013, then transfer 2016, then transfer to, Lord, to my client in 2021. Therefore, 2013 vendor did not challenge the deed. 16 vendors did not challenge the deed. And thus, Lord, a multiple cause of action have been pleaded in this particular plaint, multiple cause of action. Paragraph 27, my lord. The plaintiff is also entitled to a decree for declaration that consequence upon the deed of conveyance for the year 2000 being declared as void, the sale certificate registered before the additional register of assurance for the year 2023 is consequently void and not binding upon the plaintiffs. Lord, submission was made before the Supreme Court that subsequent after that sale, auction sale transaction, for that transaction, subject matter of challenge before the civil court. Lordship kindly look to the Supreme Court judgment, subsequent transaction. Even, it was not said that the 2012 transaction was challenged. Lordship kindly come to the prayer. C, a decree for declaration that the alleged deed of conveyance dated 16 March 2012 registered before the additional register of assurance is a second sale of the scheduled property and therefore void document, and the same is not binding on the plaintiff in any manner whatsoever. Now, Lord, deed is a void deed. Lord, that is why a declaration is needed, and for which declaration, Lord, limitation applies. Limitation in the case, because party cannot say it is void. That is why declaration is necessary if it is a void. Then if declaration is made in a plaint by by projecting the cause of action in the plaint on the envelope.
Please come to para 30 once.
30 years. Paragraph 30.
Where they plead the cause of action then?
Yes. That the cause of action for the present suit arose on 18th of November 2023 when the utter shock of the plaintiff came across the purported certificate of sale 20 September 2023. In respect of that, all that the land measuring so and so more or less, CS dag number so and so, so and so, so and so in the district of 24 Parganas, and thereafter when the plaintiff came to know about the purported sale, my lord, this is totally wrong. This pleading, my lord, is a camouflage drafting. My lord, this is under section 3. Under section 3 of the Transfer of Property Act. First known, cause of action first become known to him, Lord, on the date of execution and registration of the sale deed. This is a camouflage drafting. In favor of the defendant too, on so and so date, when the Honorable High Court at Calcutta granted liberty to the plaintiff to pursue legal remedy available in law to get the deed of 2012 in favor of the defendant number 2 declared as void by a competent court of law, same is continuing day to day. Therefore, the first cause of action arose in 2012. Second cause of action arose in 18th of November 2023. Then, my lord, sale certificate dated 20 September 2023.
Is the sale certificate annexed somewhere here?
Sale certificate. No, they have not.
You have you in your
Yes,
application
yes,
you have?
yes.
Where is that?
Yes.
They have stated about
Not
They have
certificate of
stated-
possession. Sale certificate have you annexed?
Yes, sale certificate. Sale certificate page. Yes, sale certificate and possession certificate both.
Possession certificate you showed us on the last.
Yes, yes.
Yes, sale certificate at page 86.
Page, my lord.
86.
86. And this was registered. Sale certificate was also registered.
page 346 also.
346, right.
Of the plaint.
Of the plaint. Sale certificate 346. They submitted in their plain sale certificate also, but they did not submit the sale certificate along with the documents. They mentioned in the plaint about sale certificate. That is why they claimed in the prayer for.
No, this bunch you have handed up, this is, you say, the plaint, inter plaint. So they must have
Entire
annexed,
plaint.
they must have filed the sale certificate along with the plaint.
Oh,
You have
yes,
handed over
therefore, yes, yes. I am sorry, my lord.
this is the
No,
plaint
yes, yes,
according
this
to
is the plaint, yes.
And you told us
Yeah,
that
they,
this bulky
they
because
annexed it. They annexed it.
But not annex the delivery of possession
Oh,
certificate.
সে তো কালকে বলেছি.
yes,
They did not annex the delivery
Delivery
of
of
possession
possession
certificate.
loud and clear.
And they did not annex the delivery of possession. And secondly, my lord, they
Two are
did
the same thing.
Yeah, not same thing, right? Let me conclude with regard to that part. Lord, I'm sorry.
Yes.
I'm sorry. Lord, we are
Therefore,
a
limitation,
we
barred
are
by
a
limitation.
perpetual learner in this profession.
If
Lord,
you are a perpetual learner, we are in the nursery
Lord,
stage.
in a court, my Lord, every day we are learning.
Definitely.
And
Everybody
the
is
way the submission is to be made before the court. Your lordship rightly pointed out and corrected myself.
Thank you, Mr. Banerjee.
And I beg to be obliged to your lordships.
Mr. Banerjee, apart from limitation, what other point do you have?
Yes, now, Lord, your lordship, the judgment which I wanted to place it.
Yes.
Lord, on the propositions of two grounds. Point is, Supreme Court, a question came up for consideration that say Article 58 and 59, how it can be judged. Supreme Court said it can be judged if multiple cause of action is pleaded in the plaint. Then in that case, the cause of action, first cause of action in terms of Article 58 is to be reckoned for the purpose of counting the limitation for filing a suit.
Definitely, principal cause of action is primary relief is
Primary relief. This is
Yes,
the
yes, that
view
is settled.
taken. This is the view taken in that case, my lord.
Yes.
May I
Mr.
please,
Mitru won't take any other view. The principal cause of action, the principal, it has to be judged by the principal
cause
relief.
of action,
Cause of action or
yes,
relief. whatever.
2012. Now the vendor did not.
You can cite the judgment if you
Yes, yes, Lord. About judgment. We do to judgment.
If you have two copies.
Yes.
If you have two copies.
Yes. We have given.
আগে কোনটা রেফার করছে?
দাঁড়াও। The event দিয়ে দাও, the event দাও।
The event is there. We have handed over.
You have handed over?
Yes, we handed over yesterday.
Hand over proceeding.
Lord, the event we have handed over. 2000 volume 7 SCC page 366 paragraph Lord 13.
Right.
2020 volume 7 SCC page 366.
Any particular paragraph, Mr. Banerjee?
Particular paragraph, lordship, kindly come to paragraph 13. Paragraph 13. Paragraph 14. Lord, paragraph, let me, Lord, place before your lordship, paragraph 14.
Yes.
Limitation at prescribed a time limit for institution of all these suits. এই আর একটা কপি আছে, দেখো না, দাও না।
2027 SCC 366.
The whole difficulty is, my lord, SCC does not, the paragraphs does not tally with the Supreme Court.
Yes, that is true. Paragraph. Yes, the paragraphs
yes,
won't
yes,
tell.
you are right.
The Limitation Act 1963 starts with that.
No,
It's
I am
immediately
giving
after
my
the quotation of T. Arvindandam.
I am giving you a
Niptindabad judgment.
so that you should be convenient for this.
Thank you.
Yes. Lord, let me place, Lord, paragraph 13.
13.
13. ওইটা নয়, দিন তো ওটা নয়, এক মিনিট, ওটা ভুল হয়ে গেছে, তখন ওটা মিলবে না তো, এক মিনিট। এটা এখন আর একটা কপি আছে, কেন একটাই কপি আছে আমার কাছে।
না দিয়েছি, দেখবেন দেওয়া আছে জজ সাহেবকে। কাকে তো দাদা সাহেবকে?
হ্যাঁ,
কালকে দিলাম তো।
ও কালকে দিয়েছে। ও আর একটা দিয়ে দাও না, তোমার থেকে দিয়ে দাও না, তোমারটাই দিয়ে দাও না। Lord, kindly come, আমার থেকে দিয়ে দিচ্ছি আপনার। Lord, kindly come to paragraph, my Lord, 14. The limitation.
Decide whether we should come to 13 or 14.
Yes, Lordship.
We have read 13 in any event.
Yes. 14 limitation are prescribed a time limit.
We have read 14 actually.
All suits appeals.
We have read 14 also, which part you are wanting to rely on, Mr.
Lordship. First cause of action accrued mean if the suit is based on multiple causes of action.
All right.
My Lord, that is the reason, my Lord, for this proposition. It is a case of a multiple cause of action, and principal relief, my Lord, is challenging 2012 deed.
Absolutely. Cannot be.
Now, Lord, your Lordship, kindly come to the next judgment. Next judgment I am placing before your Lordship.
We'll continue after the recess, Mr. Banerjee. We'll continue after. So it will continue. This will take some time, so we'll continue after the recess. Whenever you finish the other matter, you come back and we'll.
My juniors, my lord, have.
Mr. Rai will be always busy. Don't count it, discount him. He'll come in between. He'll come and go sometimes, but you have to carry on. If he wants, he'll have your assistance sometimes. He will have your assistance occasionally, but
And his assistant is also competent.
So Mitra is yes, you
Yes,
can
yes,
call him competent, Mr. Mitra. But Mr. Rai is competent, there is no doubt on that.
That's the difficulty, my lord. If he is not there,
No, he'll be there, he'll be there. He knows Mr. Banerjee very well, better than all of us.
Your Lordship, may I permit to mention one matter?
At this point of time, no.
Your Lordship, it's
What about?
item number 141 of today's list. It has already been disposed of on 22nd May, but is still on the list.
Acha. 141 ta kalke to be mentioned. Thank you. We'll put it as to be mentioned tomorrow. Please take the table of coming when you come. To be mentioned kalke. We'll carry on with this matter, Mr. Mitra. Let us see where it takes us. Yes, please, sir.
Lord, the judgment which I referred before your lordship.
Yes.
Lord, here the facts of the case. In this case, if your lordship kindly look to page, Lord, page 3, my lord. Toward the bottom, paragraph 7. It was internally applied that the cell deed, paragraph 7. It was internally applied that the cell deed dated to 7/2029 be cancelled, declared as being illegal, void, ineffective, not binding on them on the ground that the sale consideration fixed by the collector had not been paid in entirety by the respondent number 1. Now, Lord, if your lordship then kindly come to Lord paragraph page 5. Lord, first, second, third, fourth paragraph. The trial court held period of limitation for filing suit was 3 years from the date of execution of the sale deed. The suit was filed on 15/12/2024. Lord, in our case, Lord, my sale deed is dated 16/3/2012. My predecessor sale deed, which was sold in auction. Lord, because this was thrown into an asset of the company. And Lord, 16/3/2012 is the sale deed. And suit was filed on 7/10/2024.
Yes.
And my lord, there are two things. My lord, I'm placing, Lord, one argument before your lordship, subject to my lord's consideration. Lord, what my mind is playing, that one is making a prayer before the court is one thing. Another is entitlement to succeed is another thing. Now, Lord, with regard to making a prayer for declaration, he is not entitled because his vendor did not. 2013 vendor did not. He had notice under section 3. 2016 vendor did not. Therefore, so far the first limb of my argument, my lord, he is not entitled to make such a prayer. Second, my lord, because such a prayer has been made, it is my luck that I could be able to take a point because it is hit by Article 58 of the Limitation Act. And it does not come within the purview of 59. It comes within the purview of 58. And other prayers, Lord, are all consequential. Therefore, Lord, my submission is not plaintiff liable to be rejected. My submission is that the trial court is duty bound to decide the maintainability of the suit, irrespective whether parties take this point or not. And this is within the umbrella of prima facie case. Second, my lord, conduct. Conduct, my lord, has been incorporated by the judgment of the Honorable Supreme Court in 2008, volume 11 HCC. Volume 11 HCC judgment, my lord, conduct can also be looked into. 2008, volume 11 HCC, page 1. Lord, your lordship kindly come to paragraph 21, because it is an equitable relief. Conduct must be, Lord, that conduct, equitable relief.
What conduct here?
Conduct here is that the delivery of possession was given, that was not disclosed. High Court took possession of the property in 2015, not disclosed.
So that's suppression.
Yes, therefore it is a suppression of fact.
Yes, conduct.
No abatement in the plaint, no abatement in the injunction petition, no document have been deliberately placed.
Right.
They file an application for the purpose of recalling the division bench judgment. Lord, paragraph 21, while considering an application, paragraph 21, my lord, while considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto existence of prima facie case, balance of convenience, and irreparable injury, it must take into consideration the conduct of the parties, plus, my lord, maintainability of the suit. Therefore, maintainability of the suit and conduct of the parties, Lord, was not taken into consideration by the trial judge. Therefore, the trial court judgment is infected in the eye of law, on the anvil of the law. Now, Lord, second question. Second question is that your lordship knows very well, my lord, that when remand is permissible, if evidence are required, if evidence are already on record, appellate court can itself decide the question, because for the purpose of deciding the question of law, it cannot be, order cannot be set aside by directing the trial judge to decide the question of law. Lord, this is, and now, Lord, I may place before your lordship the ultimately the Lord Supreme Court, Lord, sustained the order of rejection of the plaint. Their prayer was for setting aside the deed of 2014 and declaration 2019 deed is void.
Yes.
And Lord, then your lordship kindly come to Shakti Bhog case. Shakti Bhog case, Lord, I have given before your lordship. This is reported in 2020 volume 17 Supreme Court cases, page 260. Lord, paragraph below 21. Paragraph below 18, 19 paragraph, 19. Shakti Bhog case, paragraph 19. We may refer to the dictum of the three-judge bench of this court in Union of India versus West Coast Papers Mills Limited, which has had an occasion to examine the expression used in Article 58 in contradistinction to possibly, my lord, your lordship, it may not.
Paragraph is not telling.
Yes, because it is in the Supreme Court and I am referring Supreme Court cases.
What is the citation of Supreme Court cases?
Lord, Supreme Court cases, my lord, is 2020 volume 17 SCC, page 270. 260. This is three judges bench, my lord. Judgment.
Yes.
হ্যাঁ, ওটা কত নম্বর প্যারাগ্রাফ বলো তো ওই জায়গাটা, ওই যে উপরে লেখা 18টা দেখো, 18 প্যারাগ্রাফটা কত? মিলছে না এটাতে।
What does your paragraph start with?
Paragraph is started, my lord, paragraph 12.
What? Here, 12. No, what does your paragraph start with? The words.
Yes, my lord,
paragraph 19 of your copy, what does it start with?
Paragraph 19 of my copy, Lord, it is started as considerately the expression used in Article 113.
That would be 10 possible in Supreme today.
Yes, paragraph 10.
Thank you, Mr.
Consequently, the expression used in Article 113 is distinct from the expression used in other articles in the first division dealing with suits, such as Article 58 when right to sue first accrues, Article 59 when facts entitling the plaintiff to have the instrument of decree cancelled or set aside, or contract rescinded first becomes known to him. Under Article 144, therefore, facts first become known to him. Another is cause of action accrues, first accrues, not facts known to him. That is the distinction between 58 and 59. That would be rewriting of the provision of doing violence of the legislature. We must assume that the Parliament was conscious of the distinction between the provisions referred to above and advised to use generic expression when the right to sue first accrues in Article 113 of the Act, inasmuch as it would also cover cases falling under Section 22 of 62 with the continuing breaches and torts. we may usefully refer to the dictum of the three-bench judgment of the Union of India versus so-and-so, which had an occasion to examine the expression used in Article 58 in distinction to Article 113. We may revert to the paragraph 19 to 21 of the said decision, which reads as follows. Then, my lord, Article 58 and 113 has been quoted here. Now, paragraph 12 of the judgment, Lord, mentioned here, similarly in Khetri Hotels Private Limited case, the paragraph 24 therein, Limitation Act, prescribed time limit of all conceivable suits, appeals, etc. Section 2J of that act defines the expression period of limitation to mean period prescribed in the schedule for suit, appeal, or application. Then 3 lays down that every suit in instituted appeal preferred application made after the prescribed shall be, for the purposes of section 4 to 24, be dismissed, even though limitation may not have set up as a defense. If the suit is not covered in any specific article, then it would fall within the residuary article. 113 is a residuary article, my lord.
This is not German. This distinction is
not
between
that.
113 and 50.
This is
and
not
it says
that.
unlike
Not
the-
only that, right?
Here,
Absolutely.
first. The
Ah,
stress
yes,
is on first.
Lordship.
Get your point.
58.
Yes.
58. Now, my lord, I am ventured to argue, place before your lordship, because I am allured, Lord, by your lordship's language used in the single bench judgment. My lord, my submission is single bench judgment is not binding on this court.
Yes.
On the binding on this court. At the same time, this is one aspect. Another aspect is, my lord, that it is one thing to say that single judgment is not binding on the division bench. On the other hand, if single judge's judgment, my lord, is referred to a division bench, if division bench differs with the views, division bench can set aside that judgment, saying that judgment overrule that, not set aside, overrule that judgment. I should not use the word set aside. But overrule the judgment. The principles enunciated therein overrule the judgment, and can say that I am not accepting that. In that context, my lord, it is not binding upon the division bench. But if another angle is, my lord, if the single bench judgment is placed before the court, and if this honorable court is of the view that the single bench judgment is right, then single bench judgment I can produce before your lordship, because very, Lord, adjective language, my lord, have been used, my lord, in the judgment itself. Lord, that language I don't find, my lord, from the Supreme Court judgment. That is why, my lord, I am being allured. If your lordship kindly permit me to place that judgment before your
You're
lordship.
taking a risk because this court has a history of holding its own judgment per inquiry. So the adjective language may not help you, but still, we are flattered enough to give you an opportunity to cite that.
Lord, so far, my lord, the
No, Mr. Banerjee, if you want to cite. We won't shut you out. Cite.
লর্ডশিপ ওই হ্যাঁ জজ সাহেবেরটা দাও হ্যাঁ আমার বিপটা কোথায় গেল রে ভাই আমার বিপটা কোথায়
So, Manna, you must have found out this judgment. Yes. Oh, Mr. Banerjee was.
Lord, ultimately I lost in that case.
Oh, then what is the proposition on which you are citing?
Yes, yes, that is I'm drawing your lordship's kind attention. Lord, page 13, 13. Page
Yes, on
13,
question
Lord,
of
toward the
limitation.
bottom.
Yes.
On the question of limitation, consideration of Article 58 and 59 of the Limitation Act.
It's an unreported judgment. You have to give a copy.
Yes, yes, I have to give
That-
a copy.
Since it's unreported,
Yes,
it's
my
a
lord,
mandate.
Yes, my lord, certainly.
Yes.
কোথায় গেল রে ভাই ওইটাই তো না on the question of limitation and consideration of Article 58 and 59 of the Limitation Act is necessary. 58 to obtain any other declaration 3 years when right to sue first accrues. 59 to cancel or set aside an instrument or decree or for rescission of a contract 3 years when facts entitling the plaintiff to have the instrument or decree cancelled or set aside or the contract rescinded first become known to him. The starting point of limitation begins to run in case of Article 59 from the date of knowledge. On the contrary, in the case of Article 58, a starting point of limitation is when right to sue first accrues. It is noteworthy that in the case of Article 58, knowledge has not made the yardstick. It can reasonably be deduced that when a person challenges the binding effect of his deed, the deed of registration, when deed legally comes into force, has to be the date when the right to sue first accrues. Lord, here I am joining the issue. Exactly, my lord, the Supreme Court has also in the even primary declaration sought was that of title without reference to any deed. The date when such title was challenged openly within the knowledge of the plaintiff could have been a relevant factor. However, when the deed is executed, deed is executed by an alleged stranger to the property affecting the title of the actual owner. The right to sue of the real owner accrues immediately. As such, in cases where execution of the deeds itself under challenge, the starting point of limitation has to be fixed on the date of registration of the transfer deed. Now, Lord, facts of the case is declaration that the deed is void. Not for setting aside. And in addition to 34 was also added. Lord, I am not arguing on that. 34, I am not arguing. Now, Lord, my respectful submission, property affecting the title. Lord, title includes the possessory title. Lord, possessory title, my Lord, 3 judges bench, my Lord, has held in AIR 1968 Supreme Court, my Lord, page 1165. Wait about হ্যাঁ এটাই তো আর্গুমেন্ট করেছি কি দরকার বেশি আর্গুমেন্ট করা যথেষ্ট এনাফ দেখানোর কোনো দরকার নেই এনাফ ওইটাই তো বলেছি আমি তুমি আমাকে 68 সুপ্রিম কোর্টটা দাও 3টে পাতা 68 সুপ্রিম কোর্ট আমার বইটা দাও 68 সুপ্রিম কোর্টটা দাও বইটা দাও
স্যার আমার কাছে আছে এটা দেখে নেন
হ্যাঁ দাও
পেজ ইনেতে গন্ডগোল হবে আমাকে দুটো দিয়ে দেন জশকে দুটো দিয়ে দিন
এই তো দুটো
দেন আমি দিয়ে দিব
Lord, this is reported case, my Lord, AIR 1968 Supreme Court. Lord, page 1165. Lord, paragraph 17. Paragraph 13 and 14. Can 17? ওখানে 17.
হ্যাঁ 17
Paragraph 17.
এক পেজ নাই উনি তো সুপ্রিমটা দিয়েছি
হ্যাঁ
What does it start with? Paragraph?
In our judgment. In our judgment, it involves an incorrect approach to our...
Year 17, para 17.
Yes. In our judgment, this involves an incorrect approach to our problem. আমারটা নেবেন আপনি একই কথা বলেছে না I am giving the book to him because he could have, although it is reported. In our judgment, this involves an incorrect approach to our problem. To express our meaning, we might begin by reading this judgment to discover if the principle that possession is good against all, but the true owner has in any way been departed from 1907 AC 70 reaffirmed the principles by stating quite clearly, it cannot be disputed that a person in possession of land in assumed character of owner and exercising peaceably the ordinary rights of ownership has perfectly good title against all the world but the rightful owner. And if the rightful owner does not come forward and assert his title by process of law within the period prescribed by the provisions of the statute of limitation applicable to the case, his right is forever extinguished and possessory owner acquires an absolute title. This is three judges bench.
Why is this German in your case, Mr. Banerjee? You were put into possession within 12 years.
Within 12 years.
So this
Therefore,
does
my adverse title, 20 article, section 27, article 64, 65.
But here in this case, you were you also allege that you were put in possession by virtue of the order of this court.
By virtue of order of the court.
In which year?
By virtue of the order of the court in 2023.
23.
But my vendor's title, my vendor's title 2012. That is.
This is on possession.
Yes.
Possessory.
That possessory title may not continue to us.
But you are admittedly not in possession since you are put in possession by virtue of order of court.
Therefore, my lord, by respectful submission in view of.
But you say Greenery, MPS Greenery had possession.
Tagged. That possession will be tagged.
But we don't know whether MPS Greenery had also possession.
Yes, had also possession.
How do you know that it had possession? Because you were put in possession.
Because High Court took possession, recital of the deed was possession has been delivered.
From MPS Greenery.
From, yes, from MPS. And my lord, High Court took possession from MPS blood in 2015. And then, my lord, it was sold in auction. Then advertisement was given. They did not file any objection as against that.
All right.
Lord, in the two newspaper, my lord, it has been published, circulated. Circulation was made. Wide circulation has been made. Thereafter, my lord, sale was made.
All right.
And I participated. Therefore, my right has been accrued. Therefore, I must have to, my lord, my rescue rapt is my vendor's title. 2012. Now, my lord, my adverse possession will be with effect from 2012. Commences from 2012. Because his possession will be tagged with me. In view of the Supreme Court, 69 Supreme Court, Lordship knows that judgment. Therefore, in any case, my lord.
Which judgment, Mr. Banerjee, I don't know.
That I can bring that, my lord.
Yes. On what point?
Tagging, Lord, whether tagging.
Tagging
that
of
my tagging. Tagging, your lordship knows that tagging. My vendor's possession will be tagged with me. Because
treated to be a continuation.
Treated to be a continuation. Treated to be a continuation. Therefore, my lord, the principal prayer, if not maintainable, then injunction cannot be granted.
Okay.
This is purely a question of law. Now, Lord, with regard to the trial judge has held, trial judge in the impugned order has held that title, whether title is there or not, that cannot be decided in this proceeding for injunction. Lord, that observation has been made by the trial judge.
So these are all prima facie findings.
Prima facie finding, tentative.
Tentatively, it can be done.
Yes. Tentatively, it can be done. My lord, I am saying that the trial judge cannot decide the title because he cannot hold a military trial. That is the reason.
Why is it? What
Yes,
is the
Lord,
judgment?
this judgment is for the reasons, Lord, that if your lordship kindly, it is for the proposition that the trial judge said that with regard to the title, it cannot be decided. But High Court on the point of Section 53A and other things held that the suit is not maintainable. The Supreme Court set aside the judgment of the High Court and restored the judgment of the trial court by holding that title question cannot be decided in an injunction petition.
In your case also, the present case also, title has not been decided by the trial court.
Title has not been decided.
So where are you citing?
Right? No, not necessary.
Just
Not
because
necessary.
Mr. Manna says you have to
Not
cite it.
necessary, not necessary, my lord. Necessary. Lord, in my case, it has been held rightly.
This is what has been done by the
This
trial
is
court.
what has been done.
But you are challenging that order. Then the order is right.
No, no.
This
I
goes
said
against
that
you.
so far that finding is concerned is right. Nothing wrong in it.
So give it to Mr. Mitra, he will cite it then. You are challenging the order and you are citing a judgment which supports the action of the
No,
learned trial.
support the action of the trial judge with regard to the finding recorded by the trial judge.
Yes, rightly held. Here
Therefore,
also it has been held,
that's
rightly
right.
held by the trial.
Therefore, my submission is with regard to that part, rightly held.
What has been incorrectly held? Why are you citing this judgment then?
Lord, let
Take
me
it
get
back.
back. Let me
Better,
get back.
better. Yes, better.
Not necessary. If he decides
Maybe
title,
counterproductive in fact.
Lord, if he decides title,
But Mr.
Lord,
Mitra,
then
you
in
can
that
take a
case-
note of this judgment.
Mr. Mitra also cannot because it is against him.
No, this is in his favor.
This
The
is
trial
in
court
his favor.
rightly said that title cannot be decided.
Rightly said.
Now be careful.
Lord, now, my Lord, with regard to Section 3, the Limitation Act. Lord, Section 3 of the Limitation Act. Lord, I have almost concluded.
No, not that. Not regarding that. We are saying that no further judgment will be cited. Because you have come to the section. That's why.
Lordship. Lord, I always, Lord, want to, Lord, I do not know whether I'm right or wrong. Because I always want to look into the statute first.
Mr. Banerjee, nobody can question your erudition.
After the statute, then if any, Lord, interpretation of a judicial interpretation is made.
With the vast experience which you have, what you are saying absolutely is
Lord,
correct.
only in the case of a casus omniscience principles, my Lord, the court can supply the
Nowadays in law colleges also, Mr.
for the
Banerjee, there is a
purpose of-
trend of citing, giving citations.
Citing,
but is being done on
but
citation basis without
that's
going
right.
to the section. Nobody
right.
knows what is in the
That is-
section.
that is-
Everybody knows what Supreme
Yes.
Court has held.
Yes. But my Lord, the question would be, my
That
Lord,
is
the
happening
statute
everywhere.
is to be.
In courts,
What the
judges,
statute
law
says.
students, everywhere.
Lordship.
That is the problem nowadays.
Yes. Now,
You
my
don't
Lord,
know what is in the
everybody is
section.
searching, my Lord,
You know what the
indignant
Supreme Court has said.
whether any judgment is there or not. Lord, now, my Lord, limitation, subject to the provisions
If
of
you are citing this for the proposition that you need not take this point, the court itself has to look into
it is the duty on the
Then
part.
section 3 is settled, everybody knows it.
That is my আর তো দরকার না judgment আর কি দরকার Your lordship relied upon the judgment in your lordship's judgment. This lordship judgment, Lord,
Section 3, the language is the court will have to consider
your
that of its
lordship
own.
said, my Lord, in page 9.
What is the proposition on one proposition?
The proposition is that the section 3, in terms of section 3, notwithstanding taking defense.
No, we just asked you whether you took the point in the court below yesterday. That does not mean you
I
cannot
did not
the
take that point in the
Limitation
court
can
below.
be taken by court itself has to see.
Court itself, it is the duty of the court to look
Definitely.
into that.
Definitely.
Therefore, this is my
And if it is on the face of the plaint, as you say.
Yes, lordship. আর কি দরকার জাজমেন্টে আর তোমার জাজমেন্টের দরকার সেকশন itself says that judgment your lordship has relied upon that judgment and that judgment has also said that in the case of declaration
Section 3 also follows my judgment.
Lordship. Lord, these are my
In that
submissions.
case, my learned friend also on the other side. In my lord's case.
Yes. Thank you so much.
এই দুটো জাজমেন্ট নিয়েছিল ওটা দেখে দিলেই তো পারতেন
আর কোনটা
ওই দুটো
Mr. Mitra, Mr. Rai is not there as you are anticipating. So should you keep it as, is there somebody to assist you or there is nobody to assist you? If you want, you can keep it on some other.
বলছে প্যারাগ্রাফ 20 টা দেখেন 15
কেন দেখাবে সেম কথাই বলেছে
If you can start, Mr. Mitra. Mr. Rai must be coming, yes. If you're, unless you're too handicapped without Mr. Rai because of the conference or we don't know. I mean, if you can start, Mr. Mitra. Points you know are very limited. I mean.
Now, my lord, firstly, my lord, if your lordships are pleased to look into the chart, my lord, the diagram.
আর একটা point, Lord, another thing, my Lord, which I forgot to, Lord, mention before your lordship, with regard to the procedure, the date is fixed for hearing of the first petition.
Yes.
There are two petitions, injunction petitions.
Yes.
There are two injunction petitions, my lord. One
Second injunction petition has also been disposed of.
Yes, now, my lord, with regard to that part,
You said no opportunity to file written objection regarding that.
yes, because no so-called notice was submitted. Now, Lord, as far as Lord, what was the prayer made in the injunction petition in both the injunction petitions? Your Lordship kindly look to the prayer in the injunction petition.
Prayer is same.
So first and second, let me
The prayer is same or different.
let me look into that, my lord. Prayer is same, but I will not say, my lord. I may verify it.
You are fishing out arguments.
No, no, no. I do not want that, my lord. আমার এটা কোথায় গেল?
এটা ফার্স্ট ইনজাংশন পিটিশন
Lord, first injunction, prayer is page কত এটা?
এটা
পেপার বুকের পেজ কত রে ভাই বলো?
দেয়নি, ওরা পেজ দেয়নি, সেটা করেনি কিছু। ওই নিচে দিকে আছে।
Page below 30.
Just read the
page 30.
We'll hear you, we'll believe you.
In view and circumstances aforesaid, it therefore prayed that the learned court may be pleased to pass an order of temporary injunction, restraining the dependent number one and on each one of them, their main agents, servants assigned from transferring, alienating, encumbering, dealing with, or disposing of, or from creating any third-party right or interest in respect of the suit property, and or encroaching upon, and or trespassing into, and or dispossessing the plaintiff from the suit property. Lord, this part was refused.
Deemed
by the
refusal,
judge,
you can say.
within the meaning of explanation 7 of section 11.
At interim stage it was granted, subsequently final stage it was not.
No, ad interim stage was not granted also.
At interim injunction was
not granted. Ad interim injunction was granted from transferring, alienating.
no.
But
At
with
interim
regard to
probably let us revisit that.
Lord,
You
kindly.
on the last occasion you had handed over some documents.
Yes.
It was rejected.
Probably in the at the ad interim stage it was granted.
Ad
Let us just
interim
check up.
injunction was granted to that extent only, my lord.
Let us just check up once.
In the second petition.
এই আমার পিটিশনটা কোথায় গেল এখান থেকে?
কোনটা, স্যার?
আমার এই পিটিশনটা
আপনার পিটিশনটা আপনার।
আরে এ সব তো রুলিং এগুলো দেখতে পাচ্ছি। আরে কোথায় গেল? আমার গেল কোথায়? আরে আমার পিটিশন গুলো গেল কোথায় এখান থেকে? না না।
You had furnished a previous order.
Yes, I have furnished it. আরে আমার পিটিশনটা এখান থেকে।
First it was refused, yes.
আমার পিটিশনটা তো নেই, সব তো জাজমেন্ট গুলো আছে।
Anyway, we are concerned only with the final temporary injunction.
Practically, my lord, the second injunction petition, Lord, that has been disposed of.
Yes.
Ultimately, that has been disposed of. Lordship, kindly look to the impugned order with that.
Right.
And second prayer, your Lordship, kindly look to the second injunction petition. Second injunction
Yes.
petition prayer. This is the first injunction prayer. Second injunction prayer, in view of the facts and
What is the difference in the second injunction?
that is why I am reading, my lord.
Possession is not there.
View of the facts and circumstances, let me read, my lord. But if I say no, possession was also, and if I look to the prayer and if it is contrary to that, my lord, then I shall be, my lord,
Please read out.
guilty. Prayed that the learned court may be pleased to pass an order of temporary injunction restraining the defendant number one and or main and agent servant assigned from changing the nature, character of the scheduled mentioned property and or from making any construction thereon in any manner whatsoever till the disposal of the instant suit. Therefore, prayer is identical. Only the with regard
Possession
to the
part is not there.
possession part is not there. Now, Lord, in the first injunction petition, possession part was there. Well, that was refused. And so far, the second injunction petition is concerned, this was granted. Therefore,
Possession was never, that
Possession
injunction
part-
was never given.
therefore, possession part was
Not given.
given. Possession part was not given.
Only third party interest and nature character was granted. Yes.
Yes, my lord. Therefore, in that case, my lord, the finding recorded by the court that I was not given an opportunity of being heard at all with regard to the second injunction petition.
But the first injunction petition also contained the same prayers and in addition contained the possession prayer.
Addition contained a possession prayer.
But these prayers
Now,
were
Lord,
already there.
on the ground, yes. Now, Lord, with regard to the first injunction petition, I am drawing your Lordship's kind attention. Your Lordship knows that judgment also. Honorable Justice Murari Mohan Datta presiding the division bench. These sorts of direction upon the trial judge is a order in terrorem.
Yes.
That does not mean
No, in terror.
that the court is precluded to grant time.
No, does not mean.
But here in this case, he said it is we are locked in view of non-availing the opportunity to file objection. And 25th, my lord, is the date. That was the fixed date, and then it was holiday, and then 26, 27.
27 put up petition.
Put up petition was filed without giving us copy to us, and then order was passed. Matter is fixed on 1-3 in respect of the first injunction petition.
They have never complied with the order of the
And that is order dated 27, my lord, 2000.
They have not served any summons.
The so-called notice was not given.
Don't reproduce whatever he's saying.
No. I
Something
will
very-
not. Before your lordship, I will not. I beg to be.
There may be Easter eggs within
No,
that.
no, lordship. Absolutely. Lord, these are my submissions.
Thank you.
Well, can I exchange the original certified copy with the Xerox one? I have handed over the one Xerox and one original.
What original?
Original.
You have a Xerox copy.
No, just another one is original is here.
Don't say original, certified
The certified copy.
Original is with the court record.
Original
This
certified-
photocopy will do
say
for us.
original?
আপনার কাছে কি
Certified copy of the order.
certified copy.
You say
Original
certified copy of the
No, both
order.
of us have photocopies.
Photocopy there. No.
One original, one certified copy and photocopy was there.
Pay us the court fees, we'll hand over. We'll give you certified copies of the certificate.
That is- I have
Pay us the
No,
court
no,
fees,
no.
we'll receive it by hand and deposit.
নেই, ছেড়ে দাও না, কথা বলছো কেন?
I don't have any.
If find me, I will take.
We'll try to find out for you.
Yes, I will.
এই আমার কাছ থেকে print করো, কে নিয়ে
এইটা বলছো,
এটা থেকে কে নিয়ে নিলো বলো তো?
This one.
Yes, sir. I
Four
will-
it's written 4 sets.
Yes, sir.
But why shouldn't you drop 340 proceedings? Now, not 340, something else. 4 sets must not have been written by the judge.
Exchanging with that photocopy.
Fair exchange. But we have a copy of this. With the complete with the 4 sets
তুই
writing.
তো
Yes.
রয়েছে করছে।
Over and out. Yes. Semester.
হ্যাঁ, সেই তো বলছি তো।
All of you, please take your seats first, then we'll start with Mr. Particularly Mr. Manna. Yes. Yes.
My lord, I have a list of dates, but my lord, before going into that, my lord, kindly once
Yes.
look into this chart, my lord, which was handed over to the court.
This list of dates or this?
This chart,
Acha.
the diagram, or whatever it is.
It looks like a Spider-Man's web. And complete with this, like this, it's coming out from his wrist.
It is done by me,
By you.
myself.
No. Thank you, Mr. Manna. Yes.
Completely technologically, my lord, handicapped. Cannot do this.
So we are also handicapped. Spider-Man has a different thing altogether. He was bitten by a spider when he was a kid. So we don't have that advantage.
Now, my lord, kindly look into this chart.
Yes.
We are concerned with 82 decimals of land in plot number 857.
Yes.
Now, the next part is also, my lord, correct, my lord. Jitendra, Jivon, Arjun, and Ratan, my lord, they were the co-owners, 4 brothers. Then, my lord, kindly come to the left-hand side. 3 of them, 1, 2, and 3, sells not 82 decimals, my lord. My documents would show that they sold, my lord, their share. They could not have sold, my lord, in any event. 82 decimals in its entirety.
Who could not have sold?
3 of them.
Oh, acha.
4 were co-owners.
Ratan did not sell to you.
Ratan did not.
All
3 of them sold their undivided share, 3/4 share in, my lord, 82 decimal to Shiv Krishna.
Right.
That was on 26th of May 1964.
Yes.
Then Shiv Krishna, in turn, sold
that 3/4
share on, my lord, in 1965 to Radhika.
Yes.
Next, my lord, is not really possibly correct. Radhika recorded her name in LR Arwar. That is correct. That would appear from page 53, but recording was not on 14th of October 2022.
That is wrong.
14th of October 2022, I got the copy.
That extract of the records. All right.
Then not on 7th, but on 6th of February 2013, not on 6th,
Not on 7th.
not on 7th,
6th.
on 6th. That's the document. I personally checked it up.
Right. 6th.
This, my lord, Radhika sold, my lord, to several persons.
This quantum is correct. 66.
No. No. I added up, it comes to 61.47%.
Even these, if these are added up, it's something else. These numbers are correct. The 7.68 meter goes.
The last part is not correct, my lord.
Which one, Mr. Mitra?
12.30
Not correct.
is not correct.
What should it be then?
Kindly give me a minute.
Yes, yes, please.
I added up, my lord. It comes to 61.47. Kindly give me a minute.
Well, the total is 61.47.
Yes.
We did not go into so much detail also, probably.
No,
Need-
possibly.
need- On principle, we'll have to see whether, I mean, you had title on.
Yes. And my lord, then towards the bottom, my lord, lordships would find Shukumar and Sujata.
Yes.
They sold 15.36 decimal. Right? Correct. Then Phony Bhushan and Mithu, my lord, they also sold 15.36.
Yes.
Mitali, Shonali, Bornali sold 18.45.
These are correct.
These are correct.
Very well.
But here, my lord, it's mixed up. Shadhun, along with Unuva, her name is not there. Unuva is there, my lord, at the top, serial number 3. Shadhun with Unuva had sold 12.3. At the top, lordship will find second item.
Yes, Shadhun and Unuva.
Third item is, my lord, Unuva, and the fourth one is Shadhun.
Yes.
Both of them had 6.15, though they sold 12.3%.
To real view.
True real view. Not, my lord, 20.50.
So this Sadhon Sukumar Phony Nomita 20.50, this is not correct according to you.
Sorry, my lord.
Sadhon plus Sukumar plus
No,
Phony plus.
no, that is not correct.
You had nothing to do with these people and in this matter.
I will tell you, lordship.
So first of all, Anuva and Sadhon sold their total
That's
share
true.
to you.
12.3 which they derived from Radhika.
Yes.
Then kindly come to the right hand side. My lord. Roton at the top.
Yes, Ratan.
Serial number 4.
The other branch, yes.
The other brother. Fourth brother.
Yes.
On 14th of March 1966, my lord, he sold his share to Khitish. Khitish, my lord, died, leaving behind Nomita, Shadhun, Phony Bhushan and Shukumar. Nomita was the widow, my lord. She is not there on the left hand side, but Shadhun, Phony Bhushan and Shukumar are there on the left hand side. So Nomita, Shadhun, Phony Bhushan and Shukumar, my lord, they sold on 1st of March 2006, my lord, 20.5% or 20.5 shatoks or my lord.
They derived from Khitish.
Yes. Derived from Khitish.
All right.
So 20.5 at the bottom, my lord, is, my lord, coming from Khitish.
20.5 plus 12.3.
Plus 12.3. Total comes to, my lord, 82 decimals.
No, total does not come to 82. 20.5 decimal plus 12.3.
No. Plus, my lord, 61.47.
61.47 comes from where?
20.5 plus 12.3 plus 18.45 of Mitali, Shonali, Bornali.
Oh, those also are there. Right.
Then, my lord, Phony Bhushan and Mithu 15.36.
All right, right. All these together make up this.
All
80.
this together makes up, my lord, it comes to 61.
So virtually all the branches ended in you, merged in real view.
Real view.
The total thing came back to you, total 82.
Yes. Realview then transferred it to me, my lord.
Yes.
Now, this is, my lord, the position of the title, my lord. So, they are now saying that MPS had purchased from the heirs of Jitendra, Jibon, Arjun, and Ratan, who had already transferred their property, my lord, in 1964 and 1966. MPS could not have, my lord, derived any title or, my lord, right over the property. My lord, that is, my lord, the factual part of it. Now, I'll show your lordship, my pleading is, my lord, I was in possession. The predecessor had applied for, my lord, raising the partition, raising the boundary wall. Permission was granted to them. And thereafter, my lord, when my client took possession, my lord, they had also again, my lord, they had also, my lord, obtained, my lord, or permission for making further construction, further boundary wall.
Boundary wall permission was given to your predecessor.
Yes, and then again to me.
Predecessor means Realview.
No, no.
Prior to that.
Yes, prior to that. Onuva, my lord, the
Onuva and all.
Ghoshes.
So Onuva and company, they also got permission, and you also got permission
subsequently. Yes. Kindly once come to page 315.
on 5 of the stay application.
No, the
Plaint.
The application.
The application probably.
I mean, injunction.
Injunction application. It does not have so many pages actually. 315. Right?
Yes. Difficult to read, my lord, but
no, we can.
Onuva, Sujata, Shadon, Sukumar.
Yes.
Atishala Mouja, etc. Dag number 853, 857.
What are 315? Out of 9. 315. 315. পারমিশন পঞ্চায়েত থেকে পারমিশন পেয়েছিল রেকর্ড করতেন একদিন ছিল শেয়ার দ্যাট
Yes. And kindly come to, my lord, page 309.
This is your permission.
Yes.
I mean your predecessors.
No, this is mine. The plaintiffs.
Yes, yes, your Lakshmi.
309.
Absolutely.
ওইটাও দেখিয়ে দেখ এটা বোধহয় এটাতে আছে না নভেলের
So at least even if they show that certificate of possession, that is pitted against these.
Apart from this, my lord, kindly once come to the hard bunch, my lord, the not the stay petition, my second application.
Second application, yes. The thicker one or the thinner one?
Thinner.
Yes.
One is plain, the other one is
one is plain. The
other
thicker one is the first.
petition.
Yeah, right.
First order 39 rule 1-2.
Yes. And this is the second. It is growing thin progressively. Actually, the first one was thicker, thinner. Stay application is still thinner, and There's an uncanny picture at page 102
Of this.
of the second application.
Oh. Oh, I see.
Two legs of a shadowy character, literally.
That was the basis of the second application, that they were trying to break open the boundary.
Oh, this is their shadow.
Now kindly come to page 100, or before that kindly come to page 90. They had filed an application.
144, yes.
Then kindly come to page 100.
But in that application, they must have claimed possession.
Then kindly come to the report.
Oh, the field inquiry report. Yes. In connection with that 144.
Yes.
Case number 59020.
Right.
The number tallies.
Number tallies.
On the scheduled date of field inquiry, the physical possession was verified at LN number such and such, 857. No person is present on behalf of Abdul Rauf. Applicant is present at inquiry spot. Respondents are in possession of total area of the said plots with mentionable area from starting of their purchase. One member of local body, so and so, and some other people were present and claimed that they all were present during creation of old concrete boundary of respondents sanctioned by the Gram Panchayat on 14th October 2015, and respondents are possessing now. Abdul is claiming to mutate their name, etc. This is, my lord, so far as, and that is why, my lord, I did not, my lord, ever claim any possession. My second application became necessary because, my lord, when they suffered the injunction before this honorable court, before the division bench, they, my lord, had taken steps to break open the boundary wall, and that is why, my lord, the second application became necessary.
All right.
Now,
but the first one was still pending, Mr. Mitra. You could have, because could have just filed a supplementary affidavit. I mean, the prayer remains the same because they now take the.
We earn more, my
lord. Now they're taking the point that they did not get any opportunity.
I shall come to that.
Yes.
Kindly look into the orders. The first order on 4th of February, kindly, since
yes.
এটা দ্রুত
এটা সার্টিফাইড কপি ফেরত নিয়ে বলতে
চোখে গিয়েছে না দিকটাতে আছে আমাদের তো Now kindly take up their application.
আচ্ছা অ্যাপ্লিকেশন থেকে
এখানে
আচ্ছা তুমি ওটা পেয়েছেন নুন আনতে পান্তা ফুরিয়ে যাচ্ছে ক্যান ওয়ান চলে এসছে আবার ফিরে আসা
তাড়াতাড়ি খেলা চেঞ্জ হয়েছে
Yes. Which page?
Kindly come to page 109. This appeal was preferred by my client because, my lord, ex parte identity order was not granted, so this appeal was preferred. Now kindly come to page. Kindly come to page 112.
Yes.
Kindly come to paragraph 16, my lord.
Yes.
At the bottom. Learned advocate appearing for the defendant number 1 also submits that no notice of injunction application or the suit was served upon the defendant number 1. He seeks an opportunity to oppose the application for injunction. Learned senior advocate appearing for the appellant submits on instruction that the advocate on record for the appellant will serve a copy. Then kindly come to paragraph 20, written objection to the injunction application, if any, by the defendant number 1 may be filed by 14th February. Reply thereto, if any, by 21st February. Learned trial judge is requested to take up the hearing of the injunction application on 26th February.
This was regarding the first injunction.
Regarding the first application, absolutely. We clarify, etc. And my lord, before that, the injunction was granted. That was, my lord, paragraph 15. It's not required, my lord, the order of injunction was granted.
Yes.
Then comes, my lord, when I moved the second application,
yes,
that was on 4th of February. Kindly come to, my lord, page 119.
119, yes.
Kindly come to page 120.
Hmm.
Towards the bottom, my lord, 3 paragraphs from the bottom. Hart considered.
Yes.
This court at the time of hearing had inquired whether a second injunction petition can be moved and prayed for. When initially one interim prayer of injunction has been refused by this court, though subsequently allowed by the Honorable High Court at Calcutta, on this court the learned advocate for the plaintiff has referred to civil revision number such and such, passed by Honorable High Court so and so. After considering the submission of the plaintiff, it appears that the observation made in so and so, wherein the Honorable Court was pleased to observe that Civil Procedure Code section 94C, Order 39, Rule 1 and 2, temporary injunction, grant of etc. On going through the observations made by the Honorable High Court at Calcutta, a second application for interim form of injunction can be considered. Then, my lord, kindly come to the ordering. The ad interim prayer is hereby allowed, but in the form of injunction, the plaintiff and the defendant number 1 and his men and agents are directed to maintain status quo in respect of nature, character, and possession of the suit property till 26 February 2025. The plaintiff is directed to take steps under Order 39, Rule 3A and B of the Code of Civil Procedure. It's nobody's case that, my lord, steps were not. On 26th of February, they did not appear. Or 26th of February was a holiday. Or was declared to be a holiday.
Yes.
Subsequently. Now, when it was declared to be the holiday, my lord, the matters were, my lord, came up in the board, my lord, on 27th of February. No, not on put up. I have taken specific instruction, not on put up.
Not on?
Not on. Put up was filed.
Sorry, put up on.
Sorry, put up was filed. Yes.
Oh, put up on the prayer of the plaintiff.
Yes.
Order dated 27/2.
Yes.
2025. The record is put up on the prayer of
Yes,
the
yes,
plaintiff.
Yes. Yes.
And my lord, thereafter, my lord, on 1st of March 2025, the court had passed the order.
But regarding the second injunction, no opportunity was given to them to file.
They did not appear. My lord, with
still,
greatest
written
of
objection direction at least could have been given by the court.
With greatest of respect, my lord, on 26th, it was declared to be a holiday.
Yes.
So, my lord, they also had some obligation to, my lord, to ensure that, my lord, steps are taken. And, my lord, if I may, put this question to myself. My lord, the division bench had fixed an order, a time limit for filing affidavit in opposition. No affidavit in opposition was filed, no prayer was made.
Regarding the first injunction, they have no defense because that was not done. But
now, my
the
lord,
Banerjee is suggesting that in the second application,
I shall come to that.
Yes.
Factually, my lord, nothing further was required to be controlled. So far as my right, title, and interest is concerned, my lord, that continues to remain uncontroverted.
but they would have a second lease of life if they were permitted to file written objection to the second application. They could have brought their points before the court. That opportunity was never given to them. There is no direction from the records that they were directed to file written objection. You say that 39 3AB complied with,
has been
therefore it was their obligation to ask for an opportunity if they wanted.
Absolutely.
Because
They
39
were required, my lord, with greatest of respect,
Yes,
they were
yes.
required to appear before the court and say that give me time, I want to file affidavit. That was not done.
All right.
And my lord, with respect, my lord, there is no explanation as to why, my lord, after 26, my lord, they took no step.
All right. All right, Mr.
And my lord, if your lordships are pleased to look into, my lord, the order impugned, my lord, 1st of March 2025. According to me, my lord, obviously I would say this, but according to me, my lord, there is no infirmity in this order. The court considers the facts and, my lord, passes the order.
What about your alleged suppression of the position? Because you were aware you filed a recall application before the company court. You filed a review application before, not the company, the MPS, the Ponzi court.
Yes.
You filed a review application. Therefore, they say that you must have been aware about the position, delivery of position, that notice that you suppressed.
I had made the application, my lord. They did not file, my lord, anything, my lord, there from which it would appear that, my lord, I was not in. My specific case is that I am in possession.
We filed the affidavit.
So therefore, the delivery of position document never came to you. I mean, you could not have been aware of that.
My specific case is from the very beginning that I am in possession.
So there was no scope of your suppression of delivery of possession. You could not have custody of the delivery of possession certificate.
No.
Very well.
In affidavit, we have disclosed. We have annexed.
And limitation also.
I shall come to that. Now, question of limitation. My lord, kindly look into my prayers. Now, kindly look into the, my lord, plaint and the prayers, my lord.
Yes.
Kindly come to page 28.
20.
A decree for declaration that the plaintiff, being the sole and absolute owner of the suit property, is well and truly entitled to enjoy the same and every part thereof, free from any disturbances by the defendants and or their main and agents. Decree for declaration that the defendant number 1 has had no manner of right, title, or interest in respect of the suit property or on any part thereof. A decree for declaration that the alleged deed of conveyance dated 16th March 2012, registered before the additional register of assurances, being such and such, is a second sale of the scheduled property and therefore a void document, and the same is not binding. Decree for declaration that the sale certificate dated such and such, registered before the additional register. Sale certificate dated 20th September 2023, registered before the additional register of assurances to Kolkata, being deed number such and such for the year 2023, is consequently void and not binding upon the plaintiff in any manner whatsoever. Decree for declaration that no right, title, and interest has passed. Then, my lord, if decree for delivery up of cancellation of the deed of conveyance dated 16th March 2012, being deed number such and such, then decree for delivery of and cancellation of the sale certificate dated 20th September 2023, registered before the additional register of assurances, permanent injunction. My lord, in my respectful submission, it cannot be said, my lord, that this delivery of cancellation and, my lord, The prayers for delivery of and cancellation, my lord, are secondary prayers. In any event, my lord, kindly consider, my lord, kindly come to your lordship's judgment. My lord, kindly look into the prayers made in the, my lord, in that suit. Page 3.
Yes.
Decree for declaration that the plaintiff has got right title and interest and/or ownership in respect of the property. B. Decree for declaration that the mother deeds of the defendant number 1 is not binding upon the plaintiff, with further declaration that the defendant number 1 has got no right title and interest in the property and has got no right to make any construction. C. A decree for declaration that the defendant number 1 has no right to demolish the existing building and structure. Then recovery of damages. Decree be passed declaring that the decree passed in such and such was registered in the registration office and not binding.
So B is the important one. Mother deeds were not binding.
Declaration only.
Declaration, yes.
That's it.
But Mr. Mitra, isn't it more or less, I mean,
I'll come to this section, matter. Kindly consider this issue.
because we also have to look into the specific fact considerations.
I shall-
Because if you are a party, you have to seek cancellation. But if you are but yes, you may say that 28 and all read together. If you want to avoid the document,
Specific relief act, a document.
cancellation of document.
Cancellation of document, my lord, sorry, that is specific relief act. It, my lord, speaks, if I remember it correctly, my lord, it speaks of a situation where, my lord, a deed prejudices some
Yes.
right, my lord, then, my lord, cancellation is required.
Yes, you are not a party to these deeds in your case. So, but that prejudices your rights.
Prejudices my right.
Yes.
The entire claim today of, my lord, either MPS or, my lord, the petition, the appellant before your lordship is on the basis of that deed.
Yes.
Now, my lord, I have to, my lord, get it cancelled, but because that continues to remain on record.
Yes. Right.
Then, my lord, kindly come to page 5. Page 5 of the single bench judgment, my lord,
Yes, yes.
at the top.
Yes.
Learned senior advocate appearing for the petitioner submits that since the primary relief sought by the plaintiff opposite party number 1 was a declaration that a registered deed of transfer dated such and such and its mother deeds ranging back at least such and such were not binding. The suit is governed by Article 58 of the Limitation Act. The article fixes the starting point, etc. Then, my lord, kindly come to the penultimate paragraph there. It is also submitted that Article 59 of the Limitation Act does not apply to the present case, since the suit was not for cancellation or for cancellation of or setting aside an instrument, but for a declaration that the deed in question are not binding. Then, my lord, kindly directly come to page 10.
Yes.
My lord, after the, my lord, decisions.
Yes. Yes.
Upon hearing both sides and consideration of the materials on record, it is seen that undoubtedly the plaintiff opposite party number 1 has admitted categorically possession of the defendant number 1 in respect of the suit property. In paragraphs of the plaint referred to by the petitioner, that is paragraph number such and such, the plaintiff has not minced words to express in clear terms that the defendant number 1 has been in possession of the suit property. In paragraph 14, the partners of the plaintiff company was alleged to have seen the defendant number 1 making preparation for constructing multi-story building on the suit property. In paragraph 19 of the plaintiff admits that the vendor of the defendant number 1 petitioner had obtained a decree for recovery of possession against a stranger in respect of the suit property, although it was pleaded that the present plaintiff was not bound by the said decree. Again, in paragraph such and
This
such.
was on recovery of possession prayer not being.
Yes. Then, my lord, next also, despite having admitted possession of the defendant number 1 petitioner, no prayer was made by the opposite party number 1 for amendment of the plaint to incorporate the relief for recovery of possession. It is undoubtedly true that in all these cited judgments where it was held that not praying for interim consequential relief. Then, my lord, kindly come to page 12 once.
12.
Yes.
Yes.
The last paragraph. It is evident in the present case that the possession of the defendant number 1 petitioner in respect of the suit property was admitted all along by the plaintiff. The argument that the plaintiff was in constructive possession has no legs to stand upon in the teeth of the admission by the defendant number 1 petitioner is an unlawful occupier. In fact, since the alleged transfer by Khirud and his heirs in favor of the predecessor in interest of the petitioner did not confer legitimate title on the said predecessor in interest as per the plaintiff case, the plaintiff could not turn around and claim possession through such alleged unlawful and unauthorized occupant. The moment it is admitted by the plaintiff that the defendant number 1 petitioner had not come into occupation by authority of the plaintiff, the claim of the plaintiff being in constructive possession was rendered farcical and a contradiction in terms. Then, my lord, page 14, my lord, the portion which has been relied on. The starting point of limitation begins to run in case of Article 59 from the date of knowledge. On the contrary, in Article 58, starting point of limitation is when the right to sue first accrues. Now, my lord, I pause here for a moment. Now, my lord, a deed is executed behind my back. I do not know about, my lord, the existence of the deed. My lord, can it, in my respectful submission, my lord, if I may ask myself the question, can it be said that my right to sue accrued when the deed was executed? I had no reason to know that, my lord, a deed was executed surreptitiously behind the back of, my lord, the parties. I mean, the plaintiff or its predecessors. It is noteworthy that in case of Article 58, knowledge has not been made a yardstick. It can reasonably deduct it that when a person challenges the binding effect of the deed, the date of registration when the deed legally comes into force has to be the date when the right to sue first accrues. Now, well, let's kindly read this along with the earlier paragraphs, where the plaintiff was aware of the constructions made. Now, well, let's kindly contemplate, my lord, a situation that today my lord, I have a property. Yes. Mr. X, my lord, surreptitiously, my lord, executes a deed of conveyance, my lord, claiming, my lord, to be the owner of that property and sells it to somebody else. I have no reason to know. The predecessor, or my lord, my predecessor's name was recorded in the Porcha.
22. Not back to that.
It was not in 22. It was not in 22.
You obtained the certificate copy
in 2022. Now, how do I know? Assuming, my lord, that, my lord, what my learned friend is saying, that even in 2022,
yes,
the names of my lord Hitish and the Bhadramila naam, Radhika, those were, my lord, in the odd one.
এই লাভটা এসেছে আপনার কিনেছি আড়াইশের সময় ওটা রেকর্ড হয়নি কেন?
and section 3 of the Transfer Property Act is also there, but that's a general proposition that notice is deemed to be there if somebody is in possession that you are that
Yes,
regarding
that
the
is- that
title
is the
and
basis.
registration.
That is the basis of this, my lord, judgment. That the
Why shouldn't that apply to you, Mr. Mitra? Because as per law, I mean, although that's as vague as can be, but section 3 says notice is deemed to be from the date of the registration, notice of a registered document.
Provided, my lord, provided I have notice of the document.
The registration itself is deemed to be a notice of the document
Yes.
under Transfer Property Act.
No, my lord, otherwise, kind
That's absurd, but law says so.
Unless I have, my lord, yes, it will date back to that date. It may date back to it. But, my lord, unless and until I have knowledge of the document, my lord, I cannot.
Numerous documents are being registered in numerous registration offices. We are all supposed to know about that.
It cannot be.
Yes.
As I was submitting before your lordships, my lord, a document is executed.
Transfer Property Act. You have to read something into the language of section 3 of Transfer.
Ignore.
notice to search.
The Mitra, language of this section 3 is that a person is said to have notice of a fact. The first part is in your favor, but the explanation is against you, apparently. A person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search, which you ought to have made, or gross negligence, you would have known it. Now, when you purchase the property, you should have conducted a search, which might have revealed this.
Yes.
Explanation 1 says, where any transaction relating to immovable property is required by law to be and has been effected by a registered instrument, any person acquiring such property, we are skipping over the frivolities, shall be deemed to have notice of such instrument as from the date of registration, or were not situated in one district, then the first registration.
Sorry.
I think you should just look into this.
I have one copy.
You give it to me. Say, thank you. Yes, you may say that explanation 1 has to be read in context of the first part.
To be, my lord, has to be.
But even then, this is a very risky provision because it's not possible for anybody and everybody to know about every registration going on even in your own district. We don't know what's happening in the registration office right now. But if you acquire a property, you have to search for it.
May I, my lord? A person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it.
Mr. Banerjee, was this certificate of sale certificate ever registered? It was not registered.
That was registered.
When
Sale
was it?
certificate 2023 years.
Yes,
I have spoken
registered.
about that.
In 2023.
Registered.
I've spoken about that.
Registered sale deed.
If it was registered in 2023, Mr. Banerjee,
23.
but
I know
MPS's
sale
deed was also
certificate- court
registered in
sale
2023.
certificate.
Yes, right, sorry.
Court sale certificate was
Yes, yes.
registered.
Uh,
Lord, there,
MPS did
because
the
there is a
2012
judgment of the Supreme Court in the Surface Act, my lord.
We'll come back to you, Mr.
Proceed.
Mr. Banerjee. Yes.
Now, my lord, may I? A person is said to have notice of a fact when he actually knows that fact. My lord, I know the fact, my lord, when
this does not come.
Yes. Or when, but for willful abstination from an inquiry or search which he ought to have made or gross negligence, he would have known it.
Per se, this also does not affect you.
Because
Yes, sorry.
Lordships are aware, my lord, that my lord, these records are maintained, my lord, in two manners. My lord, one is by name and the other is by, my lord, property.
Properties, yes.
These searches are made by, if the searches are made by name, my lord, I was searching on the basis of, my lord, the four brothers, their chance.
But generally, the search is done, searches are conducted by the property.
By the name, my
Property.
Property. Because we have to see what are the encumbrances on the property. The search reports and all are obtained in respect of the property only. The registration office search is conducted in respect of the property. Because we have to find out the encumbrances on the property. We don't know who has sold to whom.
No, possible. My lord, if I know it correctly, my lord, the searches
by the name of the owner.
Yes, because my lord, it becomes difficult, possibly, my lord, to my lord search by way of the property.
The registration happens regarding the property. So there will be an entry in the corresponding entry in the registration office in respect of the property also.
I'll take it.
I have never.
I'll take it.
Neither you nor I have ever conducted a search, but generally speaking, I mean. Because the MPS deed is what is troubling us. 2012 MPS deed was a registered document.
Yes.
In respect of this property. So why shouldn't this be as opposed to section article 59? I mean, the language is very different. 58 and 59.
Yes.
But then again, you are also arguing that this is a article 59 scenario.
Yes,
you have sought for
because, my lord,
cancellation, therefore
yes, cancellation is
59
there.
comes in. Yes.
And then, my lord, explanation where any transaction relating to movable property is required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of or share in the or interest in such property shall be deemed to have notice of such instrument as from the date of registration. So, my lord, MPS also had notice of it, or my lord, they had notice of it.
Yes, but now you are seeking this.
No, that's true.
So you are barred by
They also-
limitation.
I shall come to that. I shall come to that. Or when the property is not situated in one of the sub-districts, registration instrument has been registered under 30 from the earliest date, etc.
Yes.
Now, my lord, in any event, as my lord, my prayers are for cancellation also. And my lord, it cannot be said, my lord, that the declaration is my primary prayer.
Very well. Yes. We can revisit this judgment also. No difficulty on that. So we can revisit the single bench judgment also.
No, that was on the fact, my lord, in any event, that was on the fact that, my lord, the defendant was in possession. So, my lord, the plaintiff knew some right or some claim of the plaintiff, of the defendant.
স্পেসিফিকলি ফ্যাক্ট একবার দিন তো দিয়েছেন কি একবার দিন তো Since you're exploring this, let us just look at it from all possible perspectives. Let us come to. Okay. Do you have a copy of the specific relief act?
Yes, my lord.
Now, if you come to 31, yes.
Any person against whom a written instrument is void or voidable, and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjust it in order to and order it to be delivered up and cancelled. Now, my lord, I have the instrument is void or voidable against me.
Yes.
And I have reasonable apprehension that the instrument, if left outstanding, may cause him serious injury. My lord, I squarely come under.
So then you are suing to have it adjudged void or voidable.
Yes.
And the court may deliver up and cancel it.
Yes.
And in this context, if you look at 59, it says the suit must be to cancel or set aside an instrument or decree, or for the rescission of a contract. So to cancel or set aside an instrument.
Yes.
The language of 31 is your suit will be, then this has to be read. I mean, chapter 5 of Special Relief Act starts with cancellation of instruments. So rather section 31 equates these adjudication that it is void and voidable with cancellation.
Yes,
bringing
because-
it within the fold of Article 59.
Yes, because adjudge it and order it to be delivered up and cancelled.
You can sue to have it adjudged void or voidable, and relief is the court will grant the relief granted by the court is
deliver up and
cancel. So therefore, even if you seek a declaration that it's voidable,
yes,
the remedy would lie in cancellation.
Yes.
Therefore, it's ultimately a suit to cancel
Yes.
or set aside an instrument.
Yes.
Then it brings it is
59.
brought within the fold of 59.
59.
Not the and 58 is residuary after all. Very well. Very well.
And my lord, possibly, my junior points it out.
Yes.
That my lord, Article 59 or read with Section 31. Section 31 of Specific Relief Act speaks of my lord voidable document.
That is what we are saying.
Yes.
That even if it's a void or voidable document, you have to seek, you have to assert that it's void or voidable.
That's
and the remedy granted is cancellation. Therefore, ultimately, the suit, the relief sought in the suit is cancellation. Therefore, bringing it within Article 59.
And my lord, a void document, my lord, possibly, my lord, that is why the limitation starts, my lord, from the date of knowledge.
Yes, otherwise it would be absurd because, I mean, right to sue accrues, or we have another avenue also. Article 58 has various shades because it's a residuary provision. We may say that suppose it's not a suit for cancellation, but a suit for declaration that this document does not bind me merely. It's not a void or voidable document, but does not bind me. Per se, it is not a void or voidable document, does not bind me for some reason. Then also, this right to sue, Article 58, the language is when the right to sue first accrues. Your right to sue might be constituted to accrue when it is used against you, not before that. So you can read that into
Yes,
Article
either
58
it
also.
is used against me or I come to know of it.
Yes, yes.
They may not use it against me, but I come to know of it.
Yes, that also.
It may be.
Right. So Article 58 read in the context of a deed may somewhat be seeped with the color of 59.
59.
Because 58 is residuary.
May I submit this one?
Yes.
Can it be taken up day after tomorrow? It really, my lord, I ought to have, my lord, prepared myself accordingly, but
No, not that. This was it is apparent because 58 is a residuary provision. Residuary is colorless.
Declaration and injunction, my lord, possibly yes.
Yes, residuary is utterly colorless. It does not have any color. It does not have any texture. But it has to be like a crystal ball. It has to be seen in the background of the relief which is being sought. So this right to sue first accrues. It has to be taken in the context of the relief you are seeking. If it's a declaration of title, then right to sue will accrue on a different date. If it's avoiding a document, right to sue will accrue on from a different date. So probably that single bench judgment is a bit restrictive in its interpretation.
In the facts of that case, my lord, I would again say
that is a good way of avoiding. But yes, it is very restrictive. It cannot be a general proposition. You need not come back on this. This is, I mean, you've argued sufficiently on this point.
no.
Mr. Hardhan Banerjee was put on a caveat that this court has a tendency to do this.
Yes.
But he took the risk.
Yes. Now, my lord, on the decisions, my lord, cited, my lord.
Yes.
Cited. My lord, the first one, my lord, relied on is reported in 2024, volume 4 Supreme Court cases, or my lord, I shall give the Supreme Today reference, my lord.
The names you can give, the names of the parties that will be
Fine. আমার নাম মনে থাকে না।
2027 Supreme Court cases with Dahi Ben was the first one. We remember by the names of the foods. Dahi, Shakti Bhog, food industries and all these things.
No.
So it's easier to remember.
First one is, my lord, yes, it is, my lord, Asma Latif.
Asma Latif was the first one, actually.
Possibly, my lord, that's...
Whatever, you can distinguish. Yes, maybe.
Your lordships have, my lord, the
We have.
Today copy.
We have.
But kindly come to paragraph 39, which was relied.
Relied on, yes.
Paragraph 30. Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume importance even at this stage. A court considers the question of grant of interim relief. Where interim relief is claimed in a suit before a civil court and the party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contains on that basis that interim relief should not be granted. Grant of relief in whatever form, if at all, ought to be preceded by formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. So point has to be taken. I shall come to my lord section 3. Yes.
Yes, Mr. Mitra, actually, I mean, some of the judgments with due respect, I mean, are not apt. This does not help Mr. Banerjee because here rather it says that if a point is taken,
yes,
raises a point of maintainability and is barred by law and contains so many things are there, then it will be done.
Such a satisfaction resting on appreciation of the averments in the plaint, the application for interim relief, and the written objection thereto, as well as the relevant law that is cited in support of such
The
objection.
entire thing starts with where interim relief is claimed and party to be affected raises a point of maintainability, which has not been raised here. But we'll ignore this for the time being. This has not been done here, but section 3 is there.
Section 3, my lord, court has to proceed on the basis of my plaint.
Yes, yes.
Even, my lord, even if, my lord, there was, my lord, an objection, written objection, my lord, it's a question of limitation, my lord, it's a mixed question.
Mr. Mitro, Mr. Banerjee's contention, I'll take his best contention.
Yes.
So that I can confront you. Yes. So that you can. Now, from your plaint, it is evident that the deed was executed, first deed was executed in 2012.
Yes.
It's a registered deed, it was executed 2012 and registered.
Yes.
Your suit is admittedly of the year 2024 probably, 4 or 5. 4. So therefore, from the pleadings in the plaint itself, why was it not the duty of the court to see whether the suit is maintainable?
My plaint case is that, my lord, in 2024, I come to know of all this.
Some of the paragraphs you have stated 2023 that High Court proceeding, that Ponzi proceeding was the instigation. You came to know from that probably.
I came to know, my lord, when I
Sale
tried to
certificate.
develop the property.
Yes.
I gave it to a developer, my lord. The developer, my lord, came back with this case that, my lord, there is a registered
sale certificate.
Sale certificate. Then that was, my lord, the basis, my lord. Then further inquiries were made, and my
Can you
lord,
give us that paragraph of the plaint, Mr.
Yes, my
Mitra,
friend,
just if you can.
my lord, paragraph 34 বোধহয় ছিল না? Paragraph 30, page 27.
Yes, 30.
The cause of action, no, before.
No, before that also.
Kindly. give
Yes,
me
yes. Before that we saw somewhere
Yes, kindly give me a minute.
about the developer being mentioned and all. Much before that, in fact.
No, I will tell you, Lordship.
Yes.
Paragraph 6 possibly, my lord.
Possibly, yes. Paragraph 6. Somehow in paragraph.
Yes, paragraph 6.
Yes. 6.
Plaintiff
Right.
submits that with an intent to exploit the suit property commercially in November 2023, the plaintiff intended to enter into a development agreement with an intending developer.
Yes.
And for that purpose, the plaintiff had shared copies of his title deed and document with such intending developer for conducting searches and due diligence. While conducting such searches, the said intending developer informed the plaintiff that a sale certificate dated 20th September 2023, being deed number such and such, for the year 2023, registered with the Office of the Additional Register of Assurances, Kolkata, and entered in book number 1, was coming up in the title sale report. A copy of preliminary observation of the learned advocate is annexed. The plaintiff immediately applied for certified copy of such purported sale certificate and was astonished to find that the sale certificate has been executed by so and so, the one-man committee by the High Court in favor of the defendant number 1 to sell the suit property after such sale was confirmed and made absolute by order dated such and such. The plaintiff states that such sale was held and confirmed without any notice to the plaintiff. Then, my lord, further inquiries, paragraph 8, and my lord, all this came to the knowledge of the plaintiff.
That's why we wanted to see the sale certificate also. It contains a reference to this 2012. It has to. So therefore, your first knowledge was derived from 2023. This
That is
knowledge.
my plaint case, my lord. Even if, my lord, section 3, my lord, is taken into consideration, the court had to proceed on this basis.
Yes.
My lord, the next one, my lord, is possibly Dahiben.
Dahiben, yes.
2020 volumes. Oh, Shaktibhog. Thank you. I kindly come to Shakti Bhog once, my lord.
Very well. So Banerjee said para 19 of SCC citation, and the copy he has handed over para 10 to 12.
Yes, kindly come to, my lord, paragraph 10 itself.
But this probably, this judgment is probably not so apt, as we told also, Mr. Banerjee, that this draws a distinction between 113 and 58, where right to sue accrues and right to sue first accrues. So that is a different proportion altogether. Here there is no 113 scenario. So the question is whether 58 applies at all. If 58 applies, first accrues will come in. This judgment, Mr. Banerjee, is probably on the distinction between 113 and 58. So this
That is
very well
paragraph 10.
Yes. Article 58 itself is clear in its language. First accrues. If 58 is applicable, first accrues comes.
Supreme Court said 113 is residuary.
Right, right.
Out of 59, 58, 59, 130.
Yes. Residuary in the sense any other suit. There are shades of that. 58 says any other suit. 113 says where no provision.
That's true.
So boils down to the same thing, but the language used is first suit accrues. And then this the event.
Now, next one is melodious. The event.
The event was 58 versus 59.
Paragraph 13, 14, yes. 58 versus 59.
Yes.
Paragraph 14, my lord, may I?
Yes.
The Limitation Act 1963 prescribes a time limit for the institution of all suits, appeals, etc. Then, my lord, 58, 59 are quoted. The period of limitation prescribed under Article 58 and 59 of the 1963 Act is 3 years, which commences from the date when the right to sue first accrues. In Khatri Hotel, this court held that the use of the word first between the words sue and accrued would mean that if a suit is based on multiple causes of action, the period of limitation will begin to run from the date when the right to sue first accrues. That is, if there are successive violation of the right, it would not give rise to a fresh cause of action. My lord, this is, my lord, the distinguishing factor. Successive cause of action. Or, my lord, multiple cause of action is, my lord, means this, that there are successive violation of the right, it would not give rise to a fresh cause of action, and the suit will be liable to be dismissed if it is beyond the period of limitation counted from the date when the right to sue first accrued.
Next judgment is also 3-judge bench Punjab
Yes.
versus.
A 3 judges bench of this court in state of Punjab held that the court must examine the plaint and determine when the right to sue first accrued to the plaintiff, and whether, on the assumed facts, the plaintiff is within time. The words right to sue means the right to seek relief by means of legal proceedings.
The next sentence is very vital for you.
The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit is infringed, or when there is a clear and unequivocal threat to infringe such right by the defendant against whom the suit is instituted.
So you can say that the registration itself was not a threat. There was no infringement.
There was no infringement. And, my lord, even thereafter, my lord, the permission, my lord, was obtained for construction of the boundary wall.
Yes, those are also there.
By the panchayat.
My lord, the next one is possibly, my lord, 2008, volume 11, Supreme Court cases, page 1.
Yes.
Mandali,
yes.
Rangana, my lord, paragraphs 21 and 22.
Hey, sir.
21 actually conduct of parties.
Then 22, grant of
So
injunction.
it was a long time and
And allowed, kindly look into, grant of injunction
Yes.
is an equitable relief of person who had kept quiet for a long time and allowed another to deal with the properties exclusively, ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is a very valuable property, We are not, however, oblivious of the fact that grant or refusal of injunction has serious consequences. Depending upon the nature thereof, the courts dealing with such matter must make all endeavor to protect the interest of the parties. For the said purpose, application of mind on the part of is important. My lord, once kindly come to their stay petition, the division bench order, my lord, which passed the interim order. Kindly once come to
Justice
that.
Boshak's order?
Yes, ma'am.
Yes.
Kindly come to page 112.
Yes.
At the top. So far as balance of convenience and inconvenience is concerned, the plaintiff claims to be in possession of the suit property. In any event, allowing the defendant number 1 to create any third-party interest over and in respect of the suit property in any manner whatsoever will vitiate against the requirement to protect and preserve the suit property. Prima facie balance of convenience and irreparable loss and injury are in favor of the appellant for grant of ad interim injunction. In course of hearing today, the defendant number 1 did not produce any material to suggest that the balance of convenience or the consideration of irreparable loss is in favor of the defendant number 1. This was the position. Now, my lord, I'm sorry, my lord, I made a wrong statement. Before, my lord, the Ponzi court, my lord, they filed an affidavit, and there, my lord, they have said about the possession certificate. Yes. But my lord, that, my lord, in my respectful submission is they have relied on that. That is not, my lord, a suppression of act, because my case is that my predecessor was continuously in possession, and my lord, thereafter, my lord, I came into the picture.
And why is it not a suppression? Because Mr. Mitra, if you if you place that before the court below, the trial court might have taken a different view. That if delivery of possession has been, a certificate of possession is there.
Certificate of kindly come to that document once, my lord. Though it was not there before the
page 84 of their stay.
Yes. Handed over the possession of the whole property measuring such and such, as detailed in the sale certificate, my lord. Actual physical possession, my lord, no. My lord, there is nothing to show, my lord, that MPS was in possession. There is nothing on record to show, my lord, that the one-man committee, my lord, had taken possession. And, my lord, page 84 also does not speak of, my lord, the fact that, my lord, actual physical possession was given.
But it says handed over possession to Muhammad Abdul Rauf.
Yes.
If it was only possession is taken, then it could have been notional possession, symbolic. But if possession is handed over to somebody, how can it be notional or symbolic possession?
Symbolic possession can be done, my lord.
If the court officer, if the section officer or whatever he was the nomenclature, he said, I have taken possession, that could have been symbolic possession by pasting notice.
Yes.
But handed over to somebody else.
My lord, symbolic possession can be given, my lord, with greatest of respect. My lord, if a property is tenanted.
Yes.
My lord, then, if I sell the property, I have a tenanted property, I sell the property.
Yes, symbolic possession can be taken, but can it be handed over to somebody else? I mean, that is where we are. If this bailiff or whatever the section officer of the committee said, I have taken over possession, might have meant symbolic possession, but I have given possession to somebody else. It will be a double fiction.
If I sell a tenanted property and I, my lord, say that I have
hand over possession to them,
I have given possession to the, my lord, purchaser.
All right, very well. Can be.
It can be, my
Can
lord.
be.
It can be. Apart from this, my lord, there is no other document. On the contrary, my lord, I have produced, my lord, two documents to show that
Permission to,
my lord, construct and reconstruct the boundary wall. Originally given, my lord, to the Ghoshes or
Ghoshes, yes.
Ghoshes. Yes,
Those people, yes.
And then to me, and my lord, the report of my lord, the
Police report or
police
whatever.
report.
In their 144. So
In
that
their one.
they must be knowing of this.
Page 84. Page
Ah.
84 of our application.
Our application.
Who are the section officers of the Talukdar committee? We don't know. Who are these people? No idea. Joint secretary was former district judge. In the next page we find.
Signature of the.
Anyway, let us not go into that.
There are two officers given position.
Yes?
Two officers gave position. Number 1 and 2.
Officers, who are the officers?
Dilip Kumar Dhar is the section officer.
No, section officer is the name given by the committee.
No, the number
What was
one,
their qualification? Who are they?
they are the section officer of one-man committee.
It's like saying a plaintiff filed a suit.
The section officer.
No, section officer.
Hey, Mr. Immaterial. Whoever is the section officer, let the one-man committee, it's already over. So let it have that headache.
Now, my lord, the next, my lord, বাকি দেখিয়েছেন। My lord, AIS 68 Supreme Court 1165 has been relied on.
Yes.
Paragraph 17.
Yes. There, Mr. Banerjee was submitting about MPS being in possession in view of the 2012 deed
My lord, nobody
and tagging of the possession.
nobody can speak of, my lord, MPS's possession. MPS took possession, my lord. There is no document to show that MPS ever took possession of the property.
Only the sale deed.
Only the sale deed. Nothing further.
Yes.
একটু সাইটেশনটা বলবে
এই যেটা দেখিয়েছিলেন 68 Supreme Court. May I read out, my lord, paragraph 17(1)?
Not need. We have seen it.
And then, my lord, it was said that, my lord, submitted before your lordship that this sale was advertised. True.
Yes.
I have also said that it appears that the sale was advertised. Now, my lord, advertisement, my lord, kindly take note of the fact that, my lord, even the Civil Procedure Code does not, my lord, give much credence to the advertisements. My lord, for service of writ of summons or for, my lord, setting aside of ex parte decree, my lord, there is a distinction about, my lord, the service of, my lord, by publication. I am not greatest of respect, my lord, when this submissions I hear, I always wonder, my lord, if today, my lord, that an advertisement is published saying that my house is for sale.
Yes, I also wonder that.
My lord, what
And
will
with my
happen?
reading of newspapers, I mean, it's almost nil. So deliberately.
At least, my lord, I don't look into that, my lord, second page.
Nobody looks into those advertisements. If somebody looks into those advertisements,
Yes.
yes, true.
Huh?
apply for setting aside sale on the ground that will have silver interest in would see maybe the big give it would not be taken.
In fact, my lord, may I read out the sale notice 334 of the plaint? Yes, auction. Yes. Clause 2, 334. Caution to bidders.
Plaint. What is that? Act motor.
The same, yes, either of it.
Page number?
334. As is where is.
Yes. Property is sold on as is where is, whatever there is, and no complaint basis. Bidders are advised caution to verify with the sub-registrar office as well as revenue records and shall satisfy themselves regarding the nature, description, condition, encumbrance, lien, charge, statutory dues, etc. over the property before submitting their bids. So at least, my lord, they also had that obligation. Bidders are advised to go through all the terms and conditions of sale. It's not required. Then kindly come to it also gives them right, my lord, clause 16, page 337. 16C, the purchaser may within 30 days of the sale apply for setting aside the sale on the ground that VIVG or MPS Poilan had no sellable interest in the properties. This was the position. In any event, my lord, these are, my lord, the questions of trial. Lordships can, my lord, give a direction for expeditious, my lord, hearing of the suit, my lord. In fact, my client would be too happy if, my lord, that is done. Yes. My lord, those are my responses.
Yes, Mr. Banerjee.
আমি তো কিছু খেলতে খাইনি, আপনি কেন বলবেন আবার?
ওইটুকু বলবো।
Yes. Oh, I said, well, no. I said that I did not cite any decision.
Lord, with regard to interpretation of section 3 of the Transfer of Property Act.
Yes.
Lord, explanation, TP Act, TP Act, TP Act.
না লিমিটেশন
TP Act, Transfer of
টিপি তো ওনাকে দিলেন
I did.
Oh, that's
Lord, explanation 1.
Yes, that is what
Where any transaction
confronted you with.
relating to immovable properties required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of or share or interest in such property shall be deemed to have notice of such instrument as from the date of registration. Lord, I am coming up to this. Therefore, it is a deemed notice under section 3. Lord, he cannot avoid that. Now, Lord, his vendor's right to assert infringement of his right, because according to his submission, that by that deed, his right has been infringed. His vendor did not ventilate his grievance because the moment execution and registration of the deed has been made in 2012, deemed notice. And Lord, this deemed notice, Lord, this has been incorporated in the amendment because of the Privy Council judgment. Privy Council said, your Lordship knows that judgment, that you ought to have inquired into that before purchasing the property with regard to the title to the property or not, whether any encumbrance is made or not. Therefore, you had notice. Now, Lord, the Supreme Court in that case interpreted that the Dehiben case, if your Lordship kindly come to this paragraph, Dehiben's case, paragraph 14, my learned friend has read it. As Khetri Hotels Melot case held that the use of the word first between the word sue and accrued would mean if a suit is based on multiple cause of action, the period of limitation will begin to run from the date when right to sue first accrues. That is, if there are successive violations of the right. Therefore, my lord, first of all, violation of the right, infringement of the right. Now, my lord, non-filing of the suit within a period of 3 years on the basis of a dim notice is barred under section 58. And my lord, then a 3 judgment of this court, a state of Punjab held that the court must examine the plaintiff and determine when the right to sue first accrued to the plaintiff, and when therefore right to sue first accrued to the plaintiff, Lord vendor in 2013, then his vendor in 2016, their vendors, my lord, abandoned their right by not filing a suit. Now they cannot claim to have no knowledge with regard to the deed of 2012. In the event, my lord, interpretation in terms of explanation of section 3 is made in its proper perspective. And whether on assumed fact the plaintiff is within time, the words right to sue means right to seek relief by means of a legal proceeding. Right to sue accrues only when cause of action arises. The suit, therefore, right to sue, cause of action arises in 2012 itself. The suit must be instituted when right asserted in the suit is infringed. Lord, this has nothing to do with the Lord terminus of the commencement of the period in terms of section 58.
Mr. Banerjee, they sought for declaration that the deeds are void and not binding, and also sought for delivery up and cancellation.
No, cancellation he did not pray. Cancellation with regard to the prayer of
Let us come back to the plaintiff. They prayed.
Yes, Lordship.
Regarding both the deeds, they prayed.
Yes, Lordship.
Please come back to.
Yes,
Please come
friend.
to.
Lord, prayer D, my lord.
Yes, yes.
Prayer D. Lord,
You come to prayers F and G. F and G.
F.
Page 30. Page 30.
Page 30, my lord.
30 2012 deed and page 30 F is.
Lord, see page blood 28, my lord. A decree for declaration.
That is the first relief that continues in reliefs F and A.
Lord, may I, my lord, page C first, my lord.
So you have seen declaration that it's not binding and it's void.
Not binding.
That does not end there.
Then deed. Deed of
F and G
declaration with regard to the sale certificate.
So as we are not interested in D.
Yes, then E.
We are also not interested in E.
Yes, then D.
F and H, F and G, we are very interested.
A decree for delivery and cancellation of the deed of conveyance dated so and so for the year 2012, registered before the additional register of assurance.
And
a
also
decree
G.
for delivery up and cancellation of the deed of conveyance.
Why shouldn't this be treated to be under 59?
Lord, because 59 cannot be, because in view of section 3, this is a camouflage drafting, camouflage prayer made. Section 3, my lord, dim knowledge. His vendor dim knowledge. He came into picture in 2021. He cannot come, but his vendor could have come. At that time, property was not sold. His vendor did not. Second vendor did not. 2016 vendor did not. Had notice. Therefore, this is a camouflage drafting in order to bypass section 58. bypass section 58.
All right.
Therefore, court can, as a whole, the prayer can be looked into, whether camouflage drafting or not, bypassing section 58.
Article,
sorry, my lord, Article
yes,
58.
Yes.
Now, Lord, in this particular case, Lordship kindly look to this, that here, 2000, here the FLD, 2009 was not asserted in the plaintiff, in the events case. 2014 deed declaration was claimed.
Yes.
In the events case, well, Lord, 2014 deed. But Supreme Court said, unless 2009 deed goes, you cannot claim to, therefore this is a camouflage drafting.
Here they have also sought for cancellation of the 2012.
2012.
So that does not apply here.
Yes.
Here they have actually asked for 2012 deed cancellation.
22 did cancel in order to bypass 58. But cause of action, Lord, arose because cause of action arose for his vendor. His vendor did not. Second vendor did not. Therefore, he is not entitled to claim that. Because they have, Lord, waived their right within the period of limitation.
Yes.
Therefore, in such a case, Lord, it will not be.
All right.
Now, as far as, Lord, so-called notice, Lord, Order 39, Rule A and B is to be complied with. Lord, that is what? That is the lawyer's notice, that this is the injunction order, ad interim injunction notice passed. And in terms of the procedure prescribed under Order 39, Rule 3, Lord, the plaintiff is required to, within a period of 24 hours, by sending the plaintiff copy of the injunction petition and the documents relied on at the time of granting an injunction, ad interim injunction. Lord, that does not.
Interim injunction itself says you are to show cause. The defendant is to show cause
Show
as
cause.
to why injunction should not.
Right.
Show cause is
now
is an invitation to file an objection.
Now, Lord, invitation to file an objection, so cause requisites are to be filed.
They put in the requisites.
No, they did
copies
not
are
put
sent.
the requisites.
Did never took that point anywhere.
No, yes. I argued before your lordship.
No. In the trial court, you did not ever take that point at any point of time, nor is it a part of your appeal. You have not taken this point that they have not complied with 39(3) AB. You have never taken that point.
39(3) C or 39 AB complied with. I am not on that.
So
I am on that, Lord, that 39 A and B complied.
Yes.
That does not absolve the liability of the court to issue, of the plaintiff to submit a requisites of so cause, and the injunction order is to be written in a red ink. The so cause notice in the red ink, that why within 7 days the injunction will not be granted. That so cause notice simultaneously that will be issued under Order 39 Rule 1 and 2. Because in law is.
Have you ever taken a point that the red ink was not used?
No. Lord, my point is that as per order sheet, they did not file any so cause notice for the purpose of issuance of a so cause notice to the party.
This is regarding the second injunction.
This is regarding the second injunction.
In the first injunction.
No, first
Sorry to
injunction
interrupt.
বলতে পারবে না।
The
First
order,
injunction
the
বলতে পারবে
order
না।
is covered by the first application itself.
No, impugned order is covered by the second
No.
injunction application.
Kindly look into the
Yes,
prayers of the first
yes.
application. All the prayers are.
No, Lord, practically, I am drawing your lordship kind attention. Order does not speak that this order restricted in respect of the first and this order restricted in respect of the second. But with regard to the first and second, both are taken up for consideration.
Both are disposed of also.
And both are disposed of by directing, by passing an order
By
with
granting
regard to the
prayers of the second.
Of the second.
But which were also there in the first.
And
additional
in the
prayer.
first, my lord, refusal of injunction amounting to refusal of possession. Because possession prayer was in the first.
Yes.
And therefore, my lord, in terms of 7, explanation 7 of section 11,
Right.
deemed to have been refused.
Yes.
Lord, that principle will apply mutatis mutandis in this proceeding also, in view of section 141 of the Code of Civil Procedure. Therefore, my lord, as a matter of fact, lord, the opportunity of being heard was not given by not putting the requisites before the court below. And whether he put the requisites or not, that is why interregnum period order sheet between between 2/4/24 to 2/2/24 to 3/1 2024 1/3/2024
4224.
yes.
4th
In
of
between
February
these,
to 4th,
in
2nd
between
of
these 27/2/2024 order was there, and in between this, my lord, there was no order sheet for the purpose of submission of the requisites of the so-called.
Right.
And my lord, order 39 rule 1 and 2 says that in all cases injunction will be refused, ad interim will be refused, but
We have
so-called
crossed that
notice.
stage. This is the final hearing of the.
Yes, yes. Therefore, my lord, so-called even in the case of ad interim injunction granted, lord, even in that case, so-called notice is issued by the court.
Yes.
And how so-called notice can be issued by the court unless requisites are filed by the plaintiff?
Right.
Here in this case, requisites have not been filed from the order sheet itself, it appears. Therefore, no proper
From
opportunity
the order
of being
sheet,
heard.
where does it appear that they did not put in the requisites?
No, because the order sheet said that, otherwise the order sheet mentioned the requisites have been put in and issue so-called notice to the defendants by signature of the presiding
Speaking
officer.
of the first or the second? Both.
No, second. I am speaking.
Second yes.
I am speaking with regard to second. First, my lord, need not be, because first need not be. My lord, that argument I cannot advance
Yes,
before your
second, you
lord.
are right. Second.
Because first, my lord, before the court we appeared, and therefore no so-called notice is required to be.
Second injunction, there is nothing.
Second, I am
Yes,
submitting, my
you are
lord,
right.
with regard to second.
You are right.
Therefore, so far the first injunction is concerned, refused. First injunction, the first part and second part identical. Now,
Getting
my lord,
point, Mr. Banerjee,
now
you have
second injunction application allowed.
Yes.
Both are identical. Then how it can be, my lord, bifurcated, that it is in respect of the first, not in respect of the second.
True. Yes.
Therefore, in any case, my lord, it appeared that the opportunity of being heard was not given. And with regard to the Lord, my learned friend's argument with regard to possession, that the papers that they have submitted,
Permission
that
to
the
build boundary
permission
wall.
and all these things, that they are in possession in respect of the property, and not in and we are not in possession in respect. Lord, they cannot argue, because in view of the fact that the trial court did not grant any injunction, refused injunction with regard to possession. They did not prefer any appeal against that order. Secondly, my lord, that negated the High Court, not the one-man committee delivered possession to possession. In the case of, my lord, notional possession given. Notional possession given, my learned friend is saying tenant. Lord, their notional possession is to be given. Notional possession is delivered. But when possession is delivered, the word notional cannot be attributed by him.
Mr. Banerjee, if possessory injunction was not given ultimately, then where is the question of any German suppression regarding possession? Even if they suppressed regarding possession, that does not have any German effect on the order, because in any event, possession injunction was not given to them.
To this, my lord,
that suppression would not be German then.
To this, I am praying before your lordship that he made a prayer for permanent decree for permanent injunction.
Suppose they suppressed regarding possession, they did not get any injunction regarding possession.
Yes.
So therefore, that did not have any material effect on the order.
That I will answer that.
You do answer.
Lord, I am here and now I shall answer that.
Yes.
Lord, with regard to that part, the finding has been met. I had shown before your lordship, finding has been met.
Finding that?
With regard to the possession of the plaintiff.
That they are in possession.
Finding has been met without giving any opportunity of being heard to me. With regard to the second application for injunction, may be refused, but finding is met.
Right.
And secondly, my lord, that when a decree of permanent injunction is prayed for, it is for the aid of the relief for permanent injunction. Temporary is for the aid.
Yes.
For the aid. Therefore, he is to satisfy the court submit all materials before the court. It is a discretionary relief. Why discretionary relief will be granted in his favor if his conduct is unfair?
Equitable relief at the end of the day.
Yes, equitable relief when conduct is unfair.
All right.
And learned trial judge did not have any opportunity to look into that document. Ought to have entire the judgment ought to have been in our favor. Had the opportunity been given with regard to the second injunction application, first I only want to say I wanted to take time, that is order in terrorem, he ought to have granted. It is not mandatory. In procedural matters, my lord, this is order in terrorem. That is not, my lord, that the court is powerless.
But seen from the other side, the court had the discretion to follow it or not to follow it. It chose to follow it. Why should the appellate court interfere with that discretion?
Appellate court will interfere.
The appellate court, why should
Appellate
it
court will yes. Lord, appellate court will interfere in a case where the court did not, trial court did not apply the procedural aspect, because it is hit by a doctrine of non-compliance of the procedural aspect. This is my claim. We are saying
what is the doctrine?
That is procedural aspect or audio ultimum partem. That is by giving so-called notice, by issuing so-called notice, that was not given. Injunction was granted without giving me an opportunity of being heard. Therefore, appellate court ought to have said that the procedural lapse is there. Therefore, on that ground, the injunction order is liable to be set aside. And last, my lord, that with regard to the conduct, the trial court did not say anything.
Yes.
4 corners of the impugned order, nothing is mentioned. With regard to the limitation, nothing has been considered.
Did not enclose the shell certificate in the plaint.
Plaintiff shell certificate দিয়েছে তো হ্যাঁ দিয়েছে and so far as below the construction is concerned, that we have raised a boundary wall according to our, that here in this case, because entire documents were submitted.
When did you raise the boundary wall?
Lord, in the Ponji code, my lord, we have submitted all these.
What?
But here in this case, there is no record on that, because I did not file any objection, as I was not given an opportunity of being heard.
He also raised the boundary wall?
Yes.
On their boundary wall?
No, my boundary wall, not there.
MPS boundary.
MPS raised a boundary wall. With that, my lord, we have purchased the property. Still it is existing. If any special officer go there, my lord, he will see.
There's a Bengali proverb regarding jackals fathers raising boundary walls.
Yes.
So we'll conclude arguments on this.
Lordship.
Thank you. The hearing is concluded. Judgment is reserved in the appeal. Thank you. আগে যে নামগুলো রয়েছে না, ওই নামগুলোই থাকবে, শুধু মিস্টার পার্থপ্রতিম রায়ের নামটা বাদ দিয়ে। Should you take up some other matter?
The next matter, Millard, is mine. Millard, tomorrow I'm not there. Millard, may it be Millard day after tomorrow then?
Your other side is there. একটা কল করে দিন একবার, আমাদের টাইম আছে।
Caveat আছে?
At
There is
3.
no caveat also.
What is this matter?
This is Millard. Order 41, Millard. Millard, from Millard, refusal to grant ex parte ad interim injunction.
The suit is for?
Suit is for Millard specific performance of Millard oral agreements for facilitation of sale of several lands.
Come back day after tomorrow.
So grateful.
এটা না তাহলে আপনি saying my code and in our code also. Our experience is a bit different. You are much more precise. Thank you.